So,
today we're going to begin the third installment of Hot Topics in Criminal Justice. What we're going to focus on is what it means to be criminally responsible for one's criminal actions. If you remember, we ended the last lecture with a discussion about mental illness and under what circumstances mental illness might undermine a person's autonomy. We're going to continue that discussion today by talking about the insanity defense, which is the principal way the criminal law defines who's responsible for crime. But we're also going to talk about a special subset of cases where responsibility might be an issue. Those are cases where the criminal defendant argues that his brain made him do it, that something about his neurology or biology caused the crime, and therefore he should be excused. So the first clip you saw was, I think, a very useful clip because it showed you 4 different patients who have serious mental illness. All of them had what psychiatrists would call schizophrenia. Now, popular to common wisdom, schizophrenia is not split personality. It's not multiple personality. Schizophrenia is a mental illness, the symptoms of which are usually hallucinations and delusions, impaired or disorganized thinking, flitting from one topic to another without much coherence, repetitive behavior. You saw examples of all of that in the first video. And these unfortunate people are really out of touch with reality in a very significant way. If any of these people commit a crime, they are very likely to be found insane, or at least have a plausible argument of insanity. Now, the second video was about Andrea Yates. It's probably the most famous case of insanity, of the insanity defense we've had in the last 20 years. As you know from the video, she killed all 5 of her children. She drowned them in a bathtub. And in this particular case, she argued that because of schizophrenia, she was insane. And she won that argument, at least the second time around, and she was sent to a mental hospital, which is where most people who are found insane are sent. what we're going to talk about in part is why we have an insane defense. Why do people like Andrea Yates have an excuse to their crime? Why do we say they're not guilty by reason of insanity? I think many people are confused by this. She obviously killed her five children.
Hot
How can we
topics
say
in
she's not
criminal
guilty?
justice.
It has to do with the purposes of punishment, and particularly the retributive purpose of punishment that we talked about the last lecture. The idea is that criminal law only punishes people who are blameworthy, who deserve to be punished. And the insanity defense tries to identify people who are not blameworthy, who are in fact blameless. So even though Andrea Yates committed a horrific crime, she wasn't found guilty. She was found not guilty because we can't assign blame to her. She just did not know what she was doing, or at least that's what the jury found, that she couldn't be blamed for her crime. So the question then becomes, what is insanity, right? That's a $64 million question. And in American criminal law, the insanity defense is defined very narrowly. Very few people succeed at the insanity defense. And I want to demonstrate that by telling you about a lot of famous cases, the first two of which did result in a finding of not guilty by reason of insanity, but the rest of which did not. So we have Andrea Yates first. She was found insane at least the second time around. Her lawyers argued that because of her delusions, she came to believe that she was possessed by the devil, or at least the devil was telling her to kill her children, and that her children might be possessed by the devil as well, unless she killed them. In other words, the argument was if she killed them, her kids would go to heaven. If she didn't kill them, they'd go to hell. So that was her argument, and a jury ended up being convinced by that, ended up finding her not guilty by reason of insanity. I'm going to talk more about her case in a second. Right now, I'm just going to be briefly describing a number of cases. The second case where a person was found not guilty by reason of insanity that I want to talk about is a very famous one. This is John Hinckley. You all know that he tried to assassinate President Reagan. He came to believe that Jodie Foster would fall in love with him if he killed the President of the United States. So the defense argued in his case that because of his mental illness, and he did have a mental illness, he had perhaps not a mental illness as serious as Andrea Yates, but nonetheless a serious mental illness. Because of his mental illness, he came to believe something that just couldn't be true. It was delusional, that if he killed the president, the actress Jodie Foster would find him attractive. They also argued that he was compelled to commit his crime. So they made both of those arguments, and he was found insane. But the Yates case and the Hinckley case are pretty rare. We don't see many cases like that. So here's a third case. You may know this case, Jeffrey Dahmer. He asserted insanity defense, and I think the defense attorneys thought they might have a good argument. Why? Because his case is very bizarre. He would kill people, then cut them up into little pieces, keep them in the refrigerator, and snack on the body parts. Obviously, extremely bizarre behavior. He asserted insanity defense in Wisconsin, but he lost. His insanity defense was rejected. Here's another case. James Holmes. You may remember this. It's fairly recent. This is an individual who went to a movie theater in Colorado. He killed 12 people and badly hurt 70, or at least hurt 70 other people. As you can see from the slide, people at the time described his behavior bizarre, freaky, incoherent, and rambling. So he argued as a result of an illness that he should not be found guilty. The court and the jury did not buy his insanity defense. He was convicted. Another case, Charlie Manson, made famous by the Beatles song Helter Skelter. There have also been movies about this case. He convinced his followers that African Americans were about to take over the country. And so he wanted to try to prevent that, but his plan to do so was relatively strange. He got his followers to attack white people, Sharon Tate and her acquaintances, all of whom were white, and then tried to set it up to make it look like blacks did it in the hopes that race war would be ignited, and thus there would be an opportunity to make sure that blacks didn't take over the country. He clearly was suffering from schizophrenia. He had a serious mental illness, but he refused insanity defense. He did not want to assert insanity defense. So despite what many people think about the Charlie Manson case, insanity was actually never raised. There's another case, the Unabomber case, the case of Theodore Kaczynski. Theodore Kaczynski mailed letter bombs to a number of different people in the country, all of whom were involved in technology, all of whom were somehow involved in developing technological innovations. And unfortunately, 3 of those people were killed by his letter bombs. A number of other people were badly hurt. Even the prosecution witnesses thought that Kaczynski had schizophrenia. There was no doubt about it. He had a serious mental illness. But he refused, also, just like Charlie Manson, he refused to assert insanity defense. He did not want to be labeled mentally ill. In fact, in his famous manifesto, he said, "I would rather die than be called mentally ill." It's another case where many people think, oh, the insanity defense was an issue, but in fact, it was not. And he ended up pleading guilty to 3 counts of capital murder. So he's in prison right now because he's not found not guilty by reason of insanity. The last case is Jared Loughner. This was the individual who killed a federal judge and badly harmed Gabriel Giffords, a United States representative who was still suffering the consequences. In the weeks before the killing, he became incredibly bizarre. And after the killing, it was clear he was blatantly mentally ill. They had to put him in a padded cell. He obviously had severe mental problems. But he and his lawyer decided they couldn't win an insanity defense, at least in the state of Arizona, which has a very narrow insanity formulation, and they ended up pleading guilty. So he also is serving time. So only the first 2 cases, the Yates and Hinckley cases, was there a finding of not guilty by reason of insanity. Even though all these other people had serious mental illness, they ended up being found guilty either because the jury rejected the verdict or because they didn't want to raise the defense or they did not want to be called mentally ill. And in fact, that's what we find across the country. As you can see here, 4 states have gotten rid of the insanity defense. So can't even raise the kinds of arguments we've been talking about. And the insane defense is raised in a very small portion of cases, less than 0.5% of all felony cases. It does succeed occasionally, but usually when it succeeds, it's because the prosecutor says, yes, I agree, this person is seriously mentally ill. And to tell you the truth, I think the agenda of the prosecutor is, let's get this person in a mental hospital and keep them there for a very long time. I think that's what's going on in these cases. When instead, an insanity claim gets in front of a jury, it rarely wins. It wins about 25% of the time. And here in the state of Tennessee, in homicide cases, when the insanity defense is raised in front of a jury, it has not prevailed in the last 30 years. So it's extremely hard to win an insanity defense. Juries are very skeptical. In fact, some might say juries are too skeptical. It doesn't help that the insanity defense is defined so narrowly. And so when we come back, we're going to talk about the precise definitions of insanity. But first, any questions about what we just talked about? Okay. Well, last session, I promised we would talk about how the insanity defense is formulated in the United States, and that's what we're going to do. But we're also, as you can see here, going to talk about other defenses that relate to a defendant's mental state, the so-called mens rea defense, the diminished responsibility defense, and the automatism defense. So we're going to talk about all of these because they all relate to criminal responsibility, how criminal responsibility is defined in the United States. So let's start with the insanity defense, and there are essentially 2 formulations of the insanity defense, 2 different tests for insanity. Before we get into those, it's important to recognize that all insanity formulations require serious mental illness, usually mental illness of the type we saw in the first video. That is schizophrenia, some kind of psychosis, some indication the person is out of touch with reality, does not perceive reality correctly. But it's also important to realize that mental illness by itself is never a defense. There has to be mental illness, and then there has to be an impairment caused by the mental illness, and then impairment has to occur at the time of the crime. So this is the first insanity formulation. It's often called the McNaughton formulation, after Daniel McNaughton, who tried to kill Queen Victoria back in the 19th century. He was found not guilty by reason of insanity under the test that now bears his name. And you can see what the test is here. There has to be a mental disability, which the law usually calls mental disease or defect. That's the language that statutes and cases often use when they're referring to mental disability. So McNaughton test is by reason of mental disability or mental disease or defect, the person at the time of the crime had a substantial inability to know or appreciate the wrongfulness of the conduct. So this is obviously focused on an individual's cognitive abilities, cognitive impairment. Did the person understand right from wrong? So consider the Andrea Yates case again. I said we come back to that case. If she really did believe that if she did not kill her kids, they go to hell, but if she did kill her kids, they go to heaven, she had a pretty strong argument that she didn't think what she was doing was wrong. She thought what she was doing was morally justified. Now, contradicting that, as you saw in the tape, is she immediately called the police after she drowned her children, which suggests some sense of wrongfulness. But her lawyers were able to convince the jury that even though she knew what she had done violated the law, she still felt that, according to her own moral deserts and justification principles, it was okay for her to do this. Now, again, for anyone who's not mentally ill, that argument should lose. But because of her delusions, because of her hallucinations, the jury was willing to believe that she, in her world, it was permissible to do what she did, in fact, justified to do what she did. And so she was found insane. Another example, a case I actually was involved in, an individual who, like the first individual you saw in the first tape, had paranoid delusions, thought people were out to get him. In this particular case, the individual, he lived out in the country on a farm. He believed the crop dusters dusting the crops near him were actually government airplanes bombarding his house with electronic particles. And he could point to cracks in his house as evidence of this. And then one day his dog died. And he became convinced that was also due to the crop dusters. And he thought he was next. So one day he got out a shotgun and shot at the airplane, shot at a crop duster that was flying near his house. And he was found not guilty by reason of insanity. The idea being that even though objectively speaking, he clearly was violating the law. Objectively speaking, what he did was clearly wrong. By his own perceptions, according to his own paranoid delusions, he was in the right. He was justified in trying to protect himself and his property. So he was found not guilty by reason of insanity under the McNaughton test. So that's the McNaughton test. Very few people win it, but I just gave you 2 examples of people who did succeed under the McNaughton test. The second insanity formulation is sometimes called the irresistible impulse defense. It focuses not so much on cognitive impairment as opposed to volitional impairment. That is a person's ability to control behavior. Only 10 states recognize this defense. But in those 10 states, the defendant can argue either McNaughton or irresistible impulse. It's not an either or. You can argue both. So, in other words, there are 2 shots in the states that adopt irresistible impulse defense. As you can see here, the explicit definition is whether the person by reason of mental disability or mental disease and defect at the time of the crime had a substantial inability to control the behavior, acted impulsively. Consider the John Hinckley case. John Hinckley tried to assassinate President Reagan, as I said before. At the time he did so, there were roughly 100 Secret Service and police officers in the vicinity. And his lawyers argued that shows that he must have had an irresistible impulse to shoot the President of the United States. In fact, one way the irresistible impulse test is operationalized colloquially is by talking about the policeman at the elbow test. If the person who had committed the crime had a cop, an officer of the law, been standing right next to him or her, then it must have been an irresistible impulse. Well, in Hinckley's case, there were roughly 100 police officers standing near him, and that may have been what convinced the jury to find Hinckley insane. So those are the two insanity formulations. But as I said before, there are other tests. There are other defenses that a person with mental illness might be able to assert. Another defense is called the mens rea defense, or the guilty mind defense. That is, the argument is the person does not have the guilty mind necessary for the crime. Another way of putting it, which I think is actually, as the slide shows, an easier way to understand it, is the defense arguing by reason of mental disability, he or she lacked the intent required for the crime. Now, this is a hard defense to win. If you think about all the cases we've talked about up until now, the Yates case, the Hinckley case, my airplane assassin, they all intended to commit their crimes, right? They do not have this defense. And in fact, none of the people we've talked about so far lacked intent. They all intended to commit their crimes. So what's an example of someone who does have this defense? Well, there's a case that got up to the United States Supreme Court involving a man named Eric Clark. He clearly had schizophrenia, there's no doubt about it. And on the day of the offense, he was playing his music very loudly. An officer came over to tell him to shut it down or turn it down, and Clark pulled out his gun and shot the officer. So, at least objectively speaking, he's in big trouble. He intentionally killed a police officer. That's a capital offense in the state of Arizona where this occurred. But his defense was, because of his schizophrenia, he had come to believe that space aliens were invading the United States. Much like some of the delusions you saw the patients in the first tape have, he came to believe very strongly, at least this was a defense argument, that space aliens had invaded the Earth. And he thought the officer was a space alien, not a human being. So how does that prove he did not have lack of intent? If you believe his argument, and by the way, he lost his argument, but if you believe his argument,
he has the point
that he did not have the intent to commit homicide. He did not intend to kill a human being. He intended to kill a space alien, and therefore we have this defense. If he had won that argument, he still would have been convicted of something, but he would have avoided a first degree and probably a second degree murder conviction. He certainly would have avoided the death penalty had he won that argument, but he didn't in the state of Arizona. Another defense is called the diminished responsibility defense. This could be thought of as a mini insanity defense. It's someone who's not so impaired they're insane, but does have significant impairment. But this is a very narrow defense. First of all, as you can see, only about a quarter of the states recognize it, so it's not a very popular defense. Secondly, it's only available in homicide cases. It's not available in any other kind of case. And then finally, it usually requires some kind of provocation by the victim. It requires the victim to have somehow triggered the offense, or there's not going to be a defense. So an example of this, again, unsuccessful, at least partially unsuccessful, but nonetheless an example where the diminished responsibility defense is raised, a famous case out of California, where a person who clearly had some mental problems was at work, was told to go home by a supervisor. A fight ensued. They got in a fight. The defendant went back to his house, got a pistol, came back, and shot the supervisor. Shot him dead. His expert witness claimed that the defendant at the time of the crime was hearing voices that were telling him to get that guy, get that guy, get that guy, get the supervisor. He was not able to reduce his crime down to manslaughter, but he was able to reduce the charge from first-degree murder to second-degree murder based on the diminished responsibility idea that because of an illness, wasn't insane, but did have mental impairments that made him less culpable than a full-blown first-degree murderer. So that's diminished responsibility defense. The final defense I want to talk about goes by a number of names: the automatism defense, the involuntary act defense. This is a very rare defense. It involves a situation where the person has no physical control over their body. Okay, there's no link between mind and body. None of the cases we talked about so far come close to supporting the automatism defense. Andrew Yates, John Hinckley, Theodore Kadinsky, all these people were in control of their physical movements. All of them can control their fingers, arms, and legs. So they had no defense of this sort.
So
what would be a defense
like
this? A person with epileptic seizures. Okay, this is not going to happen very often, but assume a person with seizures is walking along a cliff with his best friend.
Got it.
A seizure overcomes him, sends his friend hurtling over the cliff. That would be a situation we'd have an involuntary act defense because the act, in fact, was involuntary. There was no link between mind and body. It's a reflexive action. Another example, there are a couple of cases involving sleepwalking where the argument is the person has no conscious control over the behavior. But again, very rare. People rarely commit offenses when they're having a seizure or when they're sleepwalking.
Exactly.
So you're not going to see this defense very often.
सीजर होए तो
So
खुद के लाल
those are the
लगे
5
होते हैं
defenses
चलने फिरने
that
क्राइम
are
का
most commonly associated with mental disability. I want to go back to a case we talked about at the end of the last lecture, the Leroy Hendricks case. If you remember in that case, we were talking about whether he could be preventively confined after he had served his sentence. And what we talked about is the Supreme Court case that resolved his situation by saying he could be confined, he could be preventively detained after he served his sentence if he was dangerous beyond his control. And the court ended up finding that Hendricks was dangerous beyond his control. But as I suggested at the end of that lecture, dangerous beyond control doesn't really give us much to go with. What does that mean? And I suggested, based on our discussion of the autonomy principle, that what dangerous beyond control might mean is somebody who's dangerous and lacking in autonomy is not responsible for their actions. Someone who's as impaired as the kind of people we've been talking about, especially people who've been found insane. Well, did Hendricks have any of the defenses that I've just been talking about? Probably not, based on what we talked about in the last lecture. He certainly had control over his bodily movements. He had control over his arms and legs. Okay? He clearly intended to molest children, and he clearly intended to molest his stepdaughter. There's no doubt about it. He couldn't get a diminished responsibility defense. Why? It wasn't a homicide charge that was being levied against him. But even if you forget about that particular issue, it's pretty clear he didn't have extreme mental and emotional distress at the time that he committed his molestations. That leaves the insanity defense. Well, the problem there, first and foremost, is he wasn't psychotic. He did not have hallucinations and delusions, which are typically the kind of mental disability that's required for the insanity defense. But let's assume that's not a problem. Let's assume that we can get an expert witness on the stand and says, well, he may not have been psychotic, but he has serious mental disability. That's enough for the threshold inquiry in connection with insanity. You still have to show more, right, with the insanity defense, either McNaughton or irresistible impulse. So, did he know right from wrong? Clearly he did. He knew it was wrong to molest children. He made sure he did it when no one was watching, except for the children. So he clearly knew that what he was doing was wrong. He would not have a McNaughton defense. Well, how about an irresistible impulse defense? How about that? He did say, and this was testimony presented at trial, he did say that I'm not going to stop molesting children unless you kill me. The only way I'm going to stop committing these sexual acts is if I die. That sounds like evidence of impulsivity. But would he have an insanity defense based on that? Would he have committed his child molestation offenses with a police officer standing at his elbow? It's seriously doubtful. In fact, he always made sure that he committed his offenses when no one else was around. And he clearly committed those offenses intentionally and so on. So as I suggested at the end of my last lecture, maybe the Supreme Court was wrong. If it meant by dangerous beyond control a lack of autonomy, a lack of responsibility, it may be that Leroy Hendricks' preventive confinement should not have been confirmed. But it was, so we'll leave up in the air what the law is at the Supreme Court level in terms of preventive confinement. The bottom line, though, is, as I try to illustrate throughout this lecture, including the example of Leroy Hendricks, it's very hard to win with any of these defenses. They're all narrowly defined. So that doesn't mean, though, the defense attorneys don't keep on trying. And when we come back, we're going to talk about how some defense attorneys have pushed the outer edges of mental state defenses. But right now, we're going to take a break. I'm curious if there are any questions about what we've been talking about.
I have one question. So, is there a defense for temporary insanity? I mean, I've heard that colloquially that there might be, not by reason of temporary insanity. Is that one of these defenses, or would that fall under?
That's a good question. It could come under the insanity defense. It's very hard to win those defenses, and you can imagine why. Juries are already skeptical of the insanity defense. But at least in most of these cases, like with Andrew Yates, there's a long history of psychiatric hospitalizations. John Hinckley also had a fairly long history of mental disability. Imagine a case where the person comes in and says, well, I was fine until 2 days before the offense. And then I became psychotic and I killed someone. And by the way, since then I've been fine. So it's just a temporary problem. You can see why there'd be a huge credibility issue there. At the same time, in a case I'll talk about in a second, a type of case I'll talk about in a second, but conceivably could be some kinds of temporary insanity cases that might be successful with the jury. But I think on the whole, it's very hard to win those cases. They do exist, though. It's an example of defense attorneys pushing the envelope.
And maybe you'll touch on this, but have we seen an expansion with maybe an increased focus on mental health in the insanity defense or in its success within?
An increased focus on what?
On mental health in the population. I mean, I think that there has been an increased focus on, trying to get people help when they have mental issues.
Yes, that's a very good question. Sometimes these insanity defenses trigger a popular response in two different directions. One is, why do we have this defense? If the person did the crime, they ought to do the time. There's no way this person should be found not guilty by reason of insanity. So that's one response. But another response is, well, we need to do more for these people with mental illness. Our system has failed because these people have mental illness and obviously did not get the treatment they needed. And so we've actually seen more than just a popular response. We've actually seen legislation that attempts to provide more treatment in the community for people with mental illness. Partly because we're just concerned about those people, partly also because we think it might actually prevent some of the crimes we're talking about. And it is true. As I'll talk about in more detail in a second, Andrew Yates could have benefited from more treatment. Some of the other people we're talking about could have benefited from more treatment. Certainly James Holmes. certainly Jared Loughner. Jared Loughner sought treatment and didn't get it. Jared Loughner, the one who killed the federal judge and injured Gabriel Giffords, he didn't get it. So those kinds of cases do trigger the kind of response you're alluding to. Any other questions? Okay, we'll stop here and pick up with the next topic.
हो गया प्रैक्टिस क्विज है ना हाँ mental disease or effect that cause of tension and ability to appreciate the wrong हाँ ये है चीज cause What's up, Aaron? Welcome to the stream. ये मेरा वो है ओपन इलेक्टिव है, मेरे को ऐसे ही कंटाड़ा आ रहा था पढ़ने में, तो मैं बोला स्ट्रीम चालू कर देते हैं, थोड़ा इंटरेक्शन होता रहेगा बीच बीच में और वो मोटिवेशन भी मिलेगा क्या नहीं, लोग देख रहे हैं अभी तो पढ़ना पड़ेगा.
Also been talking about the fact that those are very narrow defenses, especially for people like Hendricks who are not psychotic. It'd be very hard for Hendricks to win an insanity defense. But nonetheless, as I said at the end of the last session, defense attorneys still always try to push the envelope. That's part of their job, right? Defense attorneys make arguments for their clients. And so they often try to fit their client into one of the defenses we just got through talking about. And the more we learn about human behavior, the more we realize that there are lots of different varieties of mental problems and mental aberrations. And defense attorneys take note of that and make the kinds of arguments I'm about to discuss. So, the outer edges of mental state defenses. One example, you've all heard of this, post-traumatic stress syndrome.
I don't care
this is a diagnosis that's now in the official psychiatric manual, and it has been used in a number of cases to bolster some kind of defense. In situations involving veterans, defense attorneys will argue that war was very traumatizing, and it may have created a situation where their client, who's committed a crime, either was insane or had some other kind of defense. And so, for instance, one case involving a veteran had to do with an individual who had returned from Vietnam, was back in the States, but periodically experienced flashbacks that he was back in the war. And this is one of the symptoms of post-traumatic stress syndrome. You have a flashback to the time of the trauma, in this case, the Vietnam War. On the day of the offense, he apparently was having one of these flashbacks. And he ended up killing someone, thinking it was a Vietnamese soldier. In fact, it was a relative of his. So the defense argument was, because of PTSD, this individual was in a sense in a psychotic state. He actually was out of touch with reality. He believed he was in Vietnam when he wasn't. And in that particular case, the argument won. The jury ended up agreeing with the insanity defense. Now, that argument doesn't always win, but in this particular case, it did. I've also seen cases involving veterans and assertions of post-traumatic stress syndrome where the defense was not insanity, but rather automatism. How does that work? I mean, these people seem to be in control of their physical movements, but the argument is this, that at the time of the crime, because of the flashback, the person's essentially an automaton. They basically, because they've heard a helicopter sound or a gunshot, are thrown back into the Vietnam setting, and their reflexive action is to be a soldier. So the argument is this is a reflex action, almost like a seizure. And the advantage of that argument is, unlike with the insane defense, where remember what happens to a person found insane, they're sent to a mental hospital, preventively confined. If you win an automatism defense, it's possible you'll be released entirely. You will not be convicted of anything because it goes to the act requirement of the crime. So that's the post-traumatic stress syndrome defense in connection with veterans. It's sometimes also used in connection with battered women. And you're all familiar with this phenomena. Women who are battered by their spouses, sometimes very badly. That obviously can be very traumatic. So you can see how post-traumatic stress syndrome would figure into these cases. There was one case where a woman was beaten for years, prostituted by her husband, basically treated like a slave by her husband for years and years, finally killed her husband while he was asleep. The defense argued self-defense. The court didn't buy it. The reason being, the husband wasn't attacking her at the time of the crime. That's the traditional definition of self-defense. You only get self-defense if the threat is imminent. Since the husband was asleep, the threat wasn't imminent. Well, the backup argument was what? Diminished responsibility. This was a homicide case. She argued, okay, if I don't get self-defense, at least I should get a diminished responsibility defense. Because of the trauma, I was under extreme mental or emotional stress at the time of the offense, and I should have a defense. And this kind of defense can win. It has won. Okay, so maybe the best defense is self-defense, but a lot of courts will not buy it. And so instead, the diminished responsibility defense is a backup defense. And more courts are recognizing it. We're seeing more and more cases where this kind of defense succeeds. Then there's defenses having to do with the use of drugs. What am I talking about here? At the time of the offense, the person is psychotic. They're out of touch with reality. But why? Because they've ingested a drug. So for instance, there's one case where a person took LSD. Well, you know what happens with LSD. You can have hallucinations. This person came to believe that he's being attacked by a pack of wild dogs. He killed one of them. Unfortunately, the wild dog was actually a human.
Right.
So he was charged with first-degree murder. He asserted an insanity defense. He said, well, at the time of the offense, I was psychotic. This is an example of temporary insanity to some extent, because, of course, usually it was not an LSD. He took the LSD, all of a sudden he was quote-unquote insane, suffering from psychotic-like symptoms, but obviously after the drug wore off, no longer insane. So it's an example of what I was talking about before, and it's also an example of how these defenses don't win. This person's insane defense did not win. Maybe because it wasn't thought that he had a mental disease or defect, or maybe even if he did, nonetheless, he shouldn't win under the McNaughton test.
LSD.
Why? Because it was self-induced. Okay, he took the LSD knowing it was LSD and probably
in
knowing
itself a
that the
crime.
LSD would cause some kind of hallucination. Just like in many states, the voluntary intoxication offense doesn't exist. Why? Because even if because of intoxication, you're not intending your act, you induced your state. You induced your state of intoxication, so no defense. So what about this situation? What about a situation where the defendant's psychotic because they failed to take a drug? In particular, specifically, they failed to take an antipsychotic medication that could have prevented the psychosis from occurring. This was precisely the argument the prosecution made in the Andrew Yates case, because Andrew Yates had intentionally gone off antipsychotic medication a few weeks before she killed her 5 children. And the prosecution said, okay, she may have been psychotic, she may not have known right from wrong at the time of the offense, but it was her fault. Just like with drug-induced psychosis, this was psychosis induced by Yates's failure to take her antipsychotic medication. But as you know, she was found insane. That argument didn't work. It might have been partially because her own doctor had also been reluctant to make sure she stayed on the drug. So in other words, the blame wasn't necessarily totally assignable to Andrew Yates, but also to her doctor. So that's another example of how defense attorneys have tried to push the edges, especially this first example, drug-induced psychosis. And sometimes those arguments have won. I gave you an example of one where it didn't win, but sometimes those arguments can win. Here's one that's really pushing the envelope. So, it's called the rotten social background defense, colloquially. This doesn't necessarily involve a mental disease or defect of the type we've usually been talking about. It's more of a situational excuse. It's an argument based on a person's situation. The person might have some kind of mental problem, some kind of mental aberration, but the idea is that because of the situation they are in, they had little or no control over the behavior, or they had some kind of diminished responsibility defense. They had extreme mental and emotional stress. So for instance, we get arguments where defendants say, look, I grew up in a very impoverished neighborhood, a crime-ridden neighborhood, I was abused as a child, various other circumstances of my life, and that all added up to a situation where at the time of the crime, I had at least diminished responsibility, and maybe even some version of the insanity defense. I think you can see why this is a hard argument to win. It's sometimes called the severe environmental deprivation argument, to try to get across the idea that you're like in an extrasensory deprivation tank, not quite that bad, but you aren't normal because of the community and culture that you've grown up in. But it doesn't win because these crimes are always committed intentionally, and there's no psychosis. So it's very hard, not impossible, to win these cases, at least at trial. So all these defenses are pretty rare. Outside of perhaps the battered woman situation, it's very hard to win all of these kinds of defenses. But nonetheless, these arguments are made, and again, as we learn more about human behavior, they continue to be made. And I want to end with one last example, which, contrary to what I've been talking about, has become very popular and somewhat successful. Not very successful, but somewhat successful. These are defenses based on neurological aberrations. I told you we get into brain science. Now I'm going to do it. These kinds of defenses become much more popular with defense attorneys, partly because of the kind of thing you see here. They're much more graphic. Okay, you can show pictures of what I'm about to talk about. You can't really show a picture of post-traumatic stress syndrome or severe environmental deprivation or drug-induced psychosis. You can show pictures of neurological problems. This is a very famous case. It actually wasn't a criminal case. It's just a case involving neurological damage. You can see it was pretty serious. This is the case of Phineas Gage. He was a railway worker. He worked with explosives. One day, unfortunately, an explosion went off, drove that railway spike right through his brain, right through his frontal cortex. Believe it or not, he survived. As you can see, he survived. But his behavior changed totally. Because the spike went right through his frontal lobe, which is where the part of the brain that's basically in charge of controlling behavior, he became much more aggressive, much more willing to engage in antisocial behavior. And so, obviously, if he had committed a crime, the argument would have been, well, his brain made him do it. The defect in the brain was what caused the problem. We also see a version of neurological defenses, what could be called a neurogenetic defense. Some defense attorneys have used the study that you see represented here. It's a little complicated, but basically, as it says here, it's a study that looks at the relationship between violent behavior, low serotonin or low MAOA, and child abuse. What's low serotonin? What's low MAOA? Well, low serotonin is a neurochemical substance that helps to modulate mood, helps to modulate other kinds of psychological conditions. So it's a very important biochemical substance in the body, and research tends to suggest that if a person has low serotonin, their moods and cognition can be affected in a negative way. So what the study showed was that in the cohort of people studied, that if serotonin is very low, as represented by the red, and the person was subjected to severe child abuse, as opposed to medium or very little child abuse,
I don't mind
the potential for committing a violent crime by the age of 26 was incredibly high. Okay, in other words, the argument is if you got the combination of severe child abuse and low serotonin, you've got a situation where you have people highly predisposed to commit violent crime. So you can see how this argument might be made by a defense attorney. My client is different from the average person. They basically couldn't help themselves at the time they committed the crime. So what we see happening more and more in criminal cases are arguments based on neurology or neurogenetics. The argument that my brain or my biology made me do it. And the reason I think these have become more popular, I've already suggested, you can show pictures. You can show the jury what's different about the defendant's brain, or you can get studies like the Caspi study, which is what I'll call the study I just showed you. You can get studies like the Caspi study that give you solid research on how people with the relevant conditions are different. So when we return, we'll talk more about these neurological defenses. That's what I want to devote the rest of this lecture to. But any questions about what I've just got through talking about? Yes.
So it seems like their society is like increasing perceptiveness and concern for mental illness and what can be used as mental defenses. And do you feel that the insanity defense or any of these mental illnesses that we just talked about should be more broadly construed in light of?
Yeah, so I think you're making an interesting point that there's no doubt about it. Society now is much more sympathetic towards people with mental illness than it used to be. If you remember the first lecture, I talked about the fact that we have this rugged individualist streak in our culture, and that tends to suggest that the circumstances we're in are our choice. If we're poor, that's our problem. It's our choice to be poor. And some people, in the old days, at least extended that to mental illness. If you're mentally ill, that must be your fault somehow. But we don't have that attitude anymore. We're much more willing to say mental illness is a disease over which a person has very little control. Maybe they get treatment for it, but they're born with it or develops in early childhood under circumstances which the person can't control. And so you would think that attitude would slowly but surely percolate into the criminal justice system, that we'd see these defenses I've been talking about being interpreted more broadly by the courts or at least by juries. We're not seeing too much of that. As you can tell from what I'm saying, because what I've been describing is what's going on right now. But neurology may be a toe in the door. Neurology, if we can somehow link what's going on with the defendant to something that's going on in the brain, then maybe there will be a way of integrating what you're talking about into the criminal justice system. And it is a scientific fact that all behavior is somehow linked to the brain, right? All behavior is somehow connected to the brain. So once we learn enough about brain science, it may very well be that we'll see an expansion of the defenses. And as I'll suggest at the end of this lecture, maybe we'll see the end of the criminal justice system as we know it if we go too far down that path. Any question?
Yes. Can we link all of these insanity and different types of insanity defenses to preventative incarceration and the goal of rehabilitation and incarceration? Like, how are the crimes treated differently if the insanity defense applies?
Right, so if a person's found insane, they are sent to a mental hospital, and they're kept as long as they're considered dangerous and mentally ill. So that's basically a form of pure preventive detention, the type we talked about at the end of the last lecture. And as I said, generally speaking, that's considered impermissible. I talked about the European Court of Human Rights decision that held it was impermissible to preventively confine someone after their sentence. Hendricks also held that it's impermissible to do that unless the person's dangerous beyond their control, whatever that means. The basic idea is, unless the person is seriously impaired in their autonomy, you cannot preventively confine them. Well, if we found the person insane, we have found that their autonomy is severely impaired. So it is okay to preventively confine them. It's not violating what I called the autonomy principle during the last lecture, because these people are lacking in autonomy. Again, the Hendricks case is a tough case, because I think you make a good argument. Hendricks was not lacking in autonomy in the way we've been talking about it.
Hendricks,
No further questions. Let's take a break.
I mean, क्वेश्चन समझ नहीं है. इट्स वेरी वेग क्वेश्चन. क्या लिखते हैं इसमें? आई नो ऑप्शनल है, बट लिख सकते हैं, लिख देते हैं. आई मीन व्हाट सर्कमस्टांसेस, क्या सारा सबको जनरलाइज कैसे करूँगा? I don't know. Question is very vague.
And there are essentially three varieties of these defenses. The first type involves a simple brain scan, designed to show a tumor in the brain or some other kind of defect in the brain. This can be done through a PET scan, a SPECT scan, or magnetic resonance imaging, MRI, and it provides the jury with a picture of any defects in the brain. So that's the first kind of neurological evidence. The second kind is a brain scan, an fMRI, a functional MRI. And what this does is measure blood flows inside the brain in reaction to various stimuli. So for instance, an fMRI might show that because of low metabolism in the amygdala and the frontal cortex, a person is prone to impulsive behavior. So that's another kind of neurological evidence. And then the third type is what we've already seen, the neurogenetic kind of evidence that is illustrated by the Caspi study. So that's the kind of evidence you might see in these cases. And as I said, the cases in which we see this kind of evidence presented have skyrocketed. Many, many more cases than there used to be. But, interestingly enough, not very successful. My colleague Terry Maroney here at Vanderbilt Law School did a study of cases involving juveniles and young adults and found, as you can see here, courts tend to regard even scientifically sound neurological claims as legally irrelevant. And that's at trial and at sentencing. This study focused entirely on sentencing. You think at least at sentencing, we see some success, if not at trial. But this study found that it virtually never had an impact at trial, maybe 10% of the time it did. So even neurological evidence with those fancy-dancy pictures doesn't necessarily have a huge impact at trial or at sentencing. So why is that? And what I want to try to do now is answer that question from a legal point of view, not from a cultural point of view, but from a legal point of view. And it might help answer why those other defenses I was talking about don't do very well. The other defenses based on post-traumatic stress syndrome, drug-induced psychosis, rotten social background, and so on. Now, one answer I could give that would be very easy is all of it's based on junk science. And that to some extent may be true. For instance, the link between post-traumatic stress syndrome and crime is not clearly established. Certainly, the link between rotten social background and antisocial behavior is hard to show. With respect to neurology, the fact that someone's brain might be stimulated in a certain way now does not necessarily mean anything about what it was reacting like at the time of the crime. So that can be a huge problem. So you see that could be the kind of argument that a prosecutor can make, and it is sometimes an argument prosecution lawyers will make, that this is all junk, we shouldn't pay any attention to it. But on the other hand, some of this evidence is scientifically sound. As Professor Maroney found, even scientifically sound evidence doesn't have a big impact. And so I'm going to assume for the rest of this talk that the evidence is good. At least the neurological evidence I'm talking about has been obtained in a scientifically and methodologically sound way. Why might there still be a problem? Even on that assumption, well, it's because, you can already guess, the 5 defenses I've been talking about are so narrowly defined. But what I want to do to illustrate that point is give you examples of 2 cases where neurological evidence played a role. The first case is a made-up name, but it's a real person, Mr. Oft. Mr. Oft was a normal individual, no criminal record whatsoever until his mid-30s, when all of a sudden he became very aggressive sexually. He tried to molest his stepdaughter. He started buying and looking at pornography. He started going online and looking at pornographic sites. He was eventually committed. He started propositioning the nurses, the female nurses on the ward. Very, very different behavior than he had engaged in just a year before. The doctors finally decided to take an MRI of Mr. Off, and they found a huge tumor in his brain. They removed the tumor. Behavior stopped. All the sexually driven behavior stopped completely. But 6 months to a year later, it started all over again. Saw the same kinds of behavior, going to prostitution parlors, pornography, propositioning the nurses. Turned out, another MRI, tumor come back. They removed the tumor, behavior disappeared. This is a pretty dramatic example of how the brain might have an impact on behavior. Okay, so that's example number 1. Example number 2 is a little bit different. Mr. Chiesa, that's his real name. It's a real case. You can find it in the case books if you want to. This is an individual who apparently did have temper tantrums from time to time. He had had several confrontations with his next-door neighbors over their crossing his property. He believed they were trespassing. He told them not to do it, but they continued to do it. One day he saw them crossing his property. He called the police and said, I'm about to go down and confront these 2 guys. Went down and confronted them. There was an argument that ensued. He shot both of them dead. Okay? The defense attorney in this case got an MRI of his client. And it turned out the MRI showed that Mr. Chiesa had frontal lobe damage, FLD, frontal lobe damage, frontal lobe disorder. So it's damage to the frontal cortex, as I said before. That's the part of the brain that most neuroscientists suggest controls behavior. So the argument would be he had less control of his behavior than the average individual because of the disorder, the damage to his brain. Should either of these people have a defense? Well, let's talk about it, given what we already know about the defenses that we've been discussing. Neither of them have an involuntary act defense, right? Both of them were in control of their limbs, their arms, and their legs at the time they committed their offenses. There's no way to have an involuntary act defense. They may have acted impulsively, but that's not what the involuntary act defense is all about. It's about the mind controlling the body, and that was clearly present. What about a mens rea defense? Both of them intended their crimes. Mr. Oft intended to molest his stepdaughter, intended to proposition the nurses. Mr. Chiesa certainly intended to shoot those two individuals. Now, did he have the mens rea, the intent needed for first-degree murder? Well, it depends on how premeditation is defined. He might have been able to argue some kind of diminished responsibility defense and knocked the charge down from first-degree murder to something lower. But he certainly had some kind of intent for homicide. There's no doubt about it. So he's not going to have a strong mens rea defense. And I already just got through talking about diminished responsibility. He may have had extreme mental and emotional stress, but probably wouldn't win, even though this is a homicide case. Why? Because there was no real strong provocation by the victims. Now, if there had been, maybe a better argument by him. But at best, this is the only argument he can make, because insanity is not going to work either, as we'll get to right now. What about insanity? Well, the first hurdle that both Mr. Oft and Mr. Chiesa have to overcome is whether there's a mental disease or defect. Now, some lawyers successfully argue that if you have a neurological aberration, you do have a defect. Maybe not a mental disease, but you got a mental defect. It's right there in the brain. You can see pictures of it. So let's assume that hurdle is overcome. In some courts, it's not going to be, but let's assume it is. You still have to show, if you want an insanity defense, that because of that mental disease or defect, you meet either the McNaughton test or the irresistible impulse test. So what about the McNaughton test, knowledge of wrongfulness? Off clearly knew what he was doing was wrong. He wasn't irrational. He was impulsive. In fact, he might have committed the offense when a cop was at his elbow, but that's not this test, right? That's irresistible impulse defense. He knew what he was doing was wrong. Mr. Chiesa clearly knew it was wrong, too. He called the police before he did it. He has no McNaughton defense, even if you assume he had a mental disease or defect. Really, the only argument they can make is this one, right? That the brain defect made it very difficult for them to control their behavior. And here, at least, Mr. Oft might have a winning argument, right? Because he clearly acted very differently when he had the tumor than when he didn't. And he could say maybe the tumor basically took control. He wasn't able to control his behavior at the time of the offense because of the tumor. But even if he...
ये प्रमले में कॉमन सेंस नहीं है नहीं मेरे भाई मैं जानबूझ के क्यों हॉट टॉपिक्स इन क्रिमिनल जस्टिस पढ़ूंगा बाय गोइंग आउट ऑफ माय वे मेरी 15 जून से इंटर्म एग्जामिनेशन है वो ना पढ़ूं ओपन इलेक्टिव है पढ़ना पड़ेगा गांडा आदमी बोलता हार्वर्ड के लेक्चर्स देख भाई
Even if he wins that argument, remember, only 10 states recognize that defense. In 37 jurisdictions, this defense is not even available. So he would lose in those jurisdictions no matter how powerful his evidence is of a lack of control. Mr. Chiesa has an even harder time, right? At least with Oft, you can show that his behavior occurred when he had the tumor and only when he had the tumor. So it suggests there's a direct link between the tumor and Mr. Oft's antisocial behavior. We don't have that kind of evidence with Chiesa. We know he has frontal lobe disorder, but we don't even know if it has anything to do with the crime at all. Lots of people with FLD never commit any crimes ever. So how do we know the FLD had anything to do with Mr. Chiesa's crime? But even if we can show that link, and it would be hard to do, but even if we can show a link between the FLD and the crime, that doesn't mean the law is going to excuse him. This is probably the most important point I'm going to make here. Causation is not excuse. Just because we can point to a cause of a crime does not mean the crime is excused. If you think about it, this has to be true, because all crime is caused, at least in part, by factors over which the person has no control. Social scientists have shown, for instance, that there's a link between violent crime and fetal alcohol syndrome, a link between violent crime and psychopathy, the diagnosis of psychopathy, a link between violent crime and violent role models. If you grew up in a violent home, you're more likely to be violent. An extra Y chromosome, an extra male chromosome. There is a statistical link between that and violent behavior. Bad temper. There's a statistical link between bad tempers and aggressive behavior. But think about it. What I just described, those 5 conditions, that describes a whole bunch of criminals. And probably we could say their crimes were caused, at least in part, if not wholly, by those kinds of things. If we started giving them excuses, even partial excuses, that would change dramatically what we do in our criminal justice system. But it goes even further than that. All behavior is caused, right? Everything we do every day is caused by something, and a lot of those causes are factors over which we have no control. Our biology, what happened to us as kids, et cetera, et cetera. And if the law starts recognizing excuses when a defense attorney can point to a cause of which someone has no control, we've basically done away with the criminal justice system. We have said it's going to be very difficult for the prosecution ever to show that a person was completely culpable for their actions. And this is why the law focuses mostly on whether the person has control over their physical limbs, whether they intended the act, whether they knew right from wrong. If all of that checks off, then the person is going to be found guilty. And it avoids the question of whether the behavior was compelled or not. Because, first of all, that's almost an impossible question to answer. The way lawyers often put it, the way prosecutors often put it, was the impulse irresistible, was the impulse merely not resisted? I think that's a very good question to ask, and it's impossible to answer. But separate and apart from that, if we start trying to answer that question, it takes us down the whole determinism. And you all know what that is. The idea that all behavior is inevitable, all behavior is determined, all behavior is something over which we have no control. And if we go down that hole, we've done away with the criminal justice system. We can't justly blame anyone if all behavior is inevitable, if all behavior is compelled. So, in short, it's going to be very hard to win these defenses, even when there's strong evidence of frontal lobe disorder, for instance, as in Chiesa's case. Maybe in Off's case, there should be a victory. Because, as I said, his behavior occurs only when the tumor is there. And in no other time. That's particularly dramatic evidence of maybe really compelled behavior by a factor over which the person has no control. But the Off case is almost sui generis. It's almost unique. There are very, very few cases like this, and that's why even neurological evidence, where you have pictures, are not typically going to be convincing in criminal justice courts. But we're not done yet, right? All I've been talking about so far are defenses at trial. Just been talking about why it's hard to win at trial. It's hard to get a not guilty verdict based on this kind of stuff. But what about sentencing? Maybe at sentencing, there's a more likely chance. What about this situation? I've talked about brain defects. Go back to the Caspi study. What about this situation? We can argue these people are strongly predisposed to commit crime. 85 to 90% of the people who have these two conditions, severe child abuse, low serotonin, commit violent crime by the age of 26. But once again, not likely to win. Why? Causation is not an excuse. These are the causes, but that doesn't mean you've got an excuse. These people who commit these crimes, they have control of their physical limbs. They intend to commit those crimes. They know what they're doing is wrong. At best, you've got an irresistible impulse argument, but where's the mental disability, first of all? And secondly, usually they're going to do it when no one's around. So they're not going to do it when an officer of the law is near them. That means, legally speaking, they're not going to get a defense. But again, not going to get a defense at trial. What about sentencing? Well, when we return after the break, we're going to talk about how all this plays out at sentencing. And we'll also talk about alternatives to all of this. What are different ways of dealing with these various kinds of conditions that perhaps aren't as narrow, aren't as constraining? Should we maybe change the criminal justice system to recognize some of these kinds of conditions? So we'll take a break unless there are any questions.
Question. So how do courts actually justify, convicting people, or still, how do the courts allow for the defenses like the Caspi study or the rotten background defense in the event that it does ultimately argue that causation is an excuse? I mean, especially for rotten background, this situation essentially has caused them to commit this crime.
Yeah, so certainly. So, as your question, how do courts deal with that kind of evidence? Well, very often they'll just reject it. I mean, a judge has the authority to reject an expert witness who the judge thinks either is basing his or her opinion on junk science.
स्कूल में टीचर जैसा
the
एग्जाम
one
जैसा है.
issue I talked about earlier. But
टीचर
even if it's
अच्छा है तो
considered
तुमको
solid
मार्क्स
evidence,
मिलेंगे बाकी.
the judge
हो
can
गया.
reject a defense that doesn't neatly fit into any of the 5 categories that I was talking about. So the judge has a lot of authority. Now, if the judge doesn't think it's junk science, I think most judges will err on the side of letting it in, and then letting the jury decide whether it should make a difference or not. And as I've suggested already, juries are pretty skeptical about all this, especially the rotten social background defense. But even that defense could win, especially if you have a certain kind of jury, right? A jury that understands what a rotten social background is. Perhaps you get a sympathetic jury. So if I think that maybe answers your question as to how this plays out practically.
And then have there ever been instances where it has been found that people have had brain tumors after they've been convicted, and then that has been come up on appeal, or maybe even mental illness has been found after they've been convicted?
So, yes, it comes up quite frequently, actually, especially in the sentencing context that we're going to get to, but it can also come up in the trial context. The argument would be this, that I didn't know I had a brain tumor at the time of trial, at the time of sentencing, so I should have my conviction or my sentence revisited by the courts. It's usually framed in terms of ineffective assistance of counsel, which we're going to talk a lot about in lecture number 4. But the idea is the defense attorney should have discovered this. The defense attorney should have gotten that brain scan or that fMRI or consulted the Caspi study and made the relevant arguments. If it's not framed that way, it's actually very hard to get a conviction revisited.
Yeah, भाई हॉट टॉपिक्स इन क्रिमिनल जस्टिस सबा के एक ही पूछ रहे हैं, टाइटल में भी लिख रखा है. अबे सही बोला बे, ऐसा थोड़ी ये तो मैं बोलूँ कि एग्जाम देने गए और पोर्शन ही पता नहीं था कि ये भी है चैप्टर है, ये एक्सक्यूज थोड़ी हुआ. कोई एग्जाम देने जा रहा हूँ मैं जाके. हॉट टॉपिक्स इन क्रिमिनल जस्टिस. हाँ, यूएस की जस्टिस के बारे में, यूएस के क्रिमिनल जस्टिस सिस्टम के बारे में बात करते हैं. ओपन इलेक्टिव है. क्विज है, प्रैक्टिस क्विज क्यों दे रहे हो? प्रॉपर क्विज दो ना. प्लेन डिफेंस ट्रायल. ब्रेन डिफेक्ट वाला अबे वो रिजेक्ट कर देते हैं. उसका ट्रू भी हो सकता है, फॉल्स भी हो सकता है. Those who were subjected to serious abuse as children and have low self-crime by their mid-20s is likely to be considered a trial. True. तेरा भाई कोई वो नहीं मार रहा, फाफे नहीं मार रहा, पता है मेरे को, ध्यान से सुन रहा हूँ मैं क्या बोल रहा है मिस्टर क्रिस्टोफर स्लोबोविन.
But now we're at sentencing. And the issue is whether perhaps at least at sentencing they will get a reduced sentence because of the kinds of conditions we're talking about. Well, unfortunately, they often will not. Here you see the law, at least in federal courts, that mitigation based on mental disability of any sort, whether it's neurological or anything else, is only permissible, first of all, if it's very significant, and secondly, only with respect to nonviolent offenses. Both Mr. Oft and Mr. Chiesa committed violent offenses. So it's not going to be available, at least in the typical non-capital case, in the federal courts. State courts, you can see some differences. Some state courts are more lenient, more likely to get mitigation in some state courts, but on the whole, it's very hard even to get mitigation at sentencing, at least in non-capital sentencing. Capital sentencing, where the death penalty is involved, totally different story. The Supreme Court of the United States has said because of the high stakes involved in capital sentencing, criminal defendants have the right to introduce any and all evidence that might be mitigating. Anything having to do with the defendant's character, anything having to do with the defendant's record can get in. So as it turns out, not surprisingly, given what you see here on this screen, most cases involve neurological arguments come in capital cases. Way over 50% of the cases where neurological evidence is presented occur in capital cases, where the only issue is whether the person gets the death penalty or a life sentence. And of course, what the defendant's trying to do is get a life sentence. So, Mr. Oft, of course, is a non-capital case. He did not commit homicide. He's not going to be eligible for the death penalty. Mr. Chiesa, on the other hand, could be convicted of capital murder. So then we go to the sentencing proceeding, and this is where he's going to want to introduce his neurological evidence to try to avoid the death penalty. But he has a problem. Even if his FLD evidence is extremely persuasive, now I suggested the last session it might not be all that persuasive, but even if it's very persuasive, he's got a problem. In fact, he's got a problem, especially if it's extremely persuasive. Why? Because the same evidence that suggests mitigation also suggests what? Dangerousness, right? If he's got this frontal lobe disorder in his brain, maybe that mitigates in terms of culpability, but apparently he's liable to go off half-cocked at any moment. He's a dangerous individual. And this is a problem defense attorneys have all the time. It's called the double-edged sword problem. The problem has to do with the fact the same evidence that's mitigating can also be aggravating. So defense attorneys have to think very carefully about presenting neurological evidence in capital cases. They usually do. They usually decide to present it. But they have to frame it in ways that try to avoid the double-edged sword problem, try to avoid the jury thinking, oh my gosh, this guy is dangerous. Because in most death penalty states, dangerousness is an aggravating circumstance. In other words, the jury is entitled to consider the death penalty if the prosecution can show a person is dangerous. So it would be ironic if the defense evidence meant to be mitigating suggested the jury an aggravating circumstance, a circumstance suggests the individual is dangerous. So you can see there's some problems with presenting neurological evidence. It's hard to win at trial at all, and even at sentencing, even in capital sentencing, there can be difficulties. So what are some alternatives to what we've been talking about? Well, I think there are three that we should talk about. One is this: we broaden the diminished responsibility defense. Okay, we broaden the diminished responsibility defense, and what does that mean? Well, first of all, we no longer limit to homicide cases. Remember, diminished responsibility is limited to homicide cases. We apply it across the board to all cases. If a person has extreme mental emotional stress at the time of the crime, they should be able to get a reduction in sentence, if not in charge. Okay. Secondly, we no longer require any evidence of provocation. Remember, that's usually part of a diminished responsibility defense. There has to be some kind of provocation by the victim. No longer require that. That would obviously be much broader. It would basically be a mini insanity defense applied to all cases. Wow. And that may sound like a long shot, but it's actually what the Supreme Court is starting to do in juvenile cases. That's what the rest of this slide suggests. Okay, what we're seeing in juvenile cases, partly based on brain science, is the Supreme Court making it clear that as a constitutional matter, juveniles cannot be sentenced to death. They cannot be given mandatory life without parole sentences. Why not? Because brain science, among other things, shows that juveniles are quite different than adults. Up until really age 20, age 25, brains are quite different than brains after age 25 in the normal average individual. So in the average individual, at least through age 18, the part of the brain that deals with impulse, the amygdala and so on, is very well developed. But unfortunately, the part of the brain that controls behavior, the frontal cortex, is not as well developed. So you sort of have the worst of both worlds. Impulsivity is up, control of behavior is down. It's not actually as good as younger kids and adults. So in the teenage years, you have really the most impulsive situation as far as neurology goes. And the courts recognize that as a constitutional matter. And thus you see what you see here. Developments in psychology and brain science continue to show fundamental differences between juvenile and adult minds, for example, in parts of the brain involved in behavior control. As a result of that kind of conclusion by the Supreme Court, we get the conclusions that I talked about before, the legal conclusions. No death penalty for people who commit crimes while they're juveniles, no mandatory life without parole. And in the mandatory life without parole cases, the court has also said the individual who committed a crime while a juvenile, they might be 30 or 40 now, but now they get a hearing to determine what the rehabilitative potential is. And so their sentence might be lowered significantly, and we've seen some examples of that. Well, that's the diminished responsibility defense I'm talking about at work. Basically, it's only being applied in homicide cases, but the idea is, based on brain science and what we're coming to understand about human behavior, we're more willing to give people breaks. That really has only occurred in the sentencing context with very serious crimes, but the argument is it should be extended more broadly to other kinds of situations. So that's one alternative. Another kind of alternative is something you all should be familiar with. You saw this a lot in lecture 2. This is a hybrid system, a reform of our current system designed to reduce mass incarceration. The idea being that for less serious crimes, we impose a maximum sentence based on retribution, based on just deserts. That's lower than what we impose on people with serious crimes. That's based on just deserts. Within those maximums, though, we're very flexible based on assessments of risk, assessments of treatability. So if a person's considered low risk, they're diverted out of the system, at least if it's a less serious crime. If they're considered medium risk, we maybe put them in prison for a while, but we try to subject them to community interventions that are good at reducing crime. Same thing with the more serious crimes. You remember all this from lecture 2. Well, how would this apply here? Well, because we know more about human behavior, this system might work perfectly. We'll give everyone the maximum sentence, but within that maximum sentence, we will provide the treatment program, the rehabilitation program that best deals with the condition we think they have. Rotten social background will deal with the systems that create rotten social background. PTSD, there are treatments for PTSD. Neurological problems, maybe we can remove the tumor. Maybe there's something else we can do with respect to the neurological problems. These kinds of approaches, these flexible approaches, give us a chance to deal with it, and if we solve the problem, the person will be released. Unlike a determinate sentence regime, where it doesn't matter if we treat it successfully or not, they're going to stay in for the time demanded by just deserts. What's the downside of this? People with the conditions we're talking about might stay in longer than people who don't have the conditions we're talking about. Why? Double-edged sword problem, right? The people with these conditions might be higher risk, and thus end up being confined longer. It depends. If we can treat them, no, they won't be confined longer. But if we can't, they might be confined longer. What's the third alternative? Just give up. Give up with this whole idea of assigning blame. Give in to determinism.
Yes, yes.
That, as some social scientists claim, all behavior is inevitable, all behavior is determined. No longer try to figure out who's responsible. What would that mean? We no longer have the 5 defenses I was talking about. They'd be irrelevant, because we're no longer trying to figure out who's criminally responsible and who isn't. All we would look for is if the person commits an unjustified antisocial act. Commits a crime that's unjustified. Self-defense, they're out. But if they commit a crime that's not justified, then we go to the dispositional stage. And we decide at the dispositional stage, what is the best way of preventing this person from committing crime? Many people might be released immediately or very soon after conviction. Other people who are considered higher risk may stay in longer. This is actually not a new idea. Barbara Wooten, who eventually was knighted, Lady Wooten, suggested this way back in the 1950s. A much more recent example of this by David Eagleman, the book Incognito. David Eagleman's a neurologist, and he takes this position very seriously. He says that even very complex actions are often the result of factors over which we have no control. And if you buy that premise, it leads him to the conclusion that we should do away with the criminal justice system as we know it. We should do away with this attempt to assign blame, to figure out just deserts. We should instead go with the kind of system I just described. If it's an unjustified antisocial act, then we go right to disposition and try in a humane, dignified way to treat the problem and prevent the crime from occurring again. Now, in our last lecture, we talked about philosophical problems with this particular approach, with the approach that doesn't focus on blame, that doesn't concern itself with retribution and just deserts. But nonetheless, the more we learn about human behavior, perhaps the harder it becomes to make the argument we need to be concerned about blameworthiness and just deserts. And at least some people are convinced we should no longer be concerned about that. So that's the third alternative. Does this mean we're about to abandon retribution anytime in the near future? No, highly unlikely. It's very unlikely we'll do so. In fact, in the next lecture, we're going to talk about the death penalty, and you'll see from the death penalty lecture that retribution is still very much alive and well. It's still very much influential. But in the meantime, if you're interested in the kinds of things I've been talking about in this lecture, more about the insane defense, more about neuroscience, these are 2 possible resources. So any questions about this last session?
I'm not sure if you'd be able to answer this, but how does international criminal courts take insanity defenses?
So what is the insanity defense in other countries? I think it's a good question. It really varies, as you can imagine. A lot of countries, Scandinavian countries for instance, don't seem to care about the second part of the insanity defense. That is whether the person knew right from wrong, whether the person had an irresistible impulse or not. They just look at whether it was a serious mental illness. If it's a serious mental illness, they're handled in a special facility having to do with mentally ill people. But this goes back to lecture number 2 as well. The European system is much more rehabilitation-oriented to begin with. So it's not like, oh, we have a separate system for severely mentally ill people from the rest of the system. Yes, it is separate, but it's really all rehabilitation-oriented. So it's just, it's actually close to this third alternative in some ways. It's a situation where if we have a serious mental illness, let's treat it. Let's deal with it. But even if a person's not seriously mentally ill, in Europe, there's more likely to be a rehabilitative response to it. Doesn't mean there won't be prison time, but there might be a rehabilitative response that's actually along the spectrum fairly close to what we do with severely mentally ill people. So that's one approach. Other countries don't recognize insanity defense. That's at the other extreme. They don't care whether there's a mental illness or not.
I guess India doesn't recognize.
Okay, thank you very much. That's the end of this lecture.
I guess. I'm not sure, but I guess. Practice quiz क्यों दे रहे हो 2 क्वेश्चन की? Great functioning. Yeah, two double-edged sword. Terminal that area is the result of factors which we have no control. Yes. True. तो ये अभी वो लिखने का देगा. क्या है? अरे वो क्या है? Learners should be able to discuss the role scientific discoveries about movement of brain. Some have argued that, given what we know about human behavior, we should abandon the attempt to determine how much punishment a person deserves and instead focus on developing means of assessing risk and providing treatment designed to reduce recidivism. Identify two advantages and disadvantages of such a system. Okay. घंटा कुछ समझ नहीं आया मेरे को. क्या बोल क्या रहा है? क्या चाहिए इसको? रुक जाओ. चाहिए क्या इसको? Two advantages and two disadvantages of which system? समझा ही नहीं मेरे को. अच्छा. अच्छा, ओके, समझा. ओके, गॉट इट. वो बोल बेसिकली वो तुम 5 में से जिनको नहीं समझ आया मैं समझाता हूँ. मेरे को पता है तुम लोग को भी नहीं समझ आया. वो पूछ ये रहा है कि ऐसी सिस्टम जिसमें अपन कितना क्राइम डिजर्व करता है, जो कन्विक्टेड है आदमी, उसको कितना क्राइम मतलब कितना वो पनिशमेंट डिजर्व करता है, क्राइम नहीं, कितना पनिशमेंट डिजर्व करता है, इस पे फोकस करने के बजाय अपने इस पे फोकस करते हैं कि अपने रिस्क कैलकुलेट करें वो बंदे का कितना क्राइम हो सकता है और उसके थ्रू अपने उसको सुधारने की कोशिश करें, या उसके थ्रू वो आइडियोलॉजी के थ्रू कोई डिसीजन ले. ऐसा करें, ऐसी सिस्टम रखें. तो अब ये सिस्टम के 2 एडवांटेज पूछा है, 2 डिसएडवांटेज. ओके, गॉट इट. ये रख ले भाई. Facility. क्या हो रहा है? Thank you, sir. Tata sir. I use GameDia Cerny Zen 5. It has blue mechanical switches. It looks sexy and it's fun to type down. Proceeds to बन गया है क्या? हाँ, तो इधर दे सकती है, मैं ले लूँ, रखी है ना थाली, मैं ले लेता हूँ। तो ब्रो ये क्या हो गया? ओए ओए इतना लिखा किधर गया? ब्रो इतना लिखा किधर गया भाई? भाई ये क्या है? भाई कहाँ गया? भाई इतना लिखा मैं कहाँ गया? ओ भाई ब्रो कहाँ गया? अबे कहाँ गया भाई इतना लिखा? भाई मैं इतना लिखा चला गया सब। अब क्या लिखा मेरे को याद भी नहीं है भाई। रुक जाओ, मैं स्ट्रीम खोलनी पड़ेगी मेरे को। क्या लिखा था? शिट में ये तो मजाक हो गया। -50 सेकंड लेके जा। चला गया था 50 सेकंड पहले। भाई यार क्या स्कैम है बे। सॉरी थोड़ी देर के लिए मैं चैट नहीं पढ़ पाऊंगा, मैं कॉपी कर रहा हूँ स्ट्रीम में मैंने क्या लिखा था। committing a time gets the hand to prove their ability based on the results of that criminal justice system proceeds to evaluate the need of rehabilitation and or treatment. आगे reduce the में use the weight and the potential of crime all together. Done. ये था पहला पॉइंट मेरा। भाई क्या स्कैम था ये? क्या स्कैम था भाई? ये क्या स्कैम था? गलत स्कैम। वेरी गलत स्कैम। सॉरी, थोड़ा डिस्ट्रैक्ट हो गया। लेट मी स्टडी हुआ है मैं। स्कैम भाई क्या गलत पे मगज जाता है मेरा। ये पहले भी हो रखा है मेरे साथ यही कोर्स में। हाँ, अभी मैं सोचा था दूसरा एडवांटेज में भूल गया क्या था। वेट, आई वांट टू राइट कि ह्यूमन राइट्स का कुछ तो वो होता है, सीन होता है, बट दैट्स नॉट एन एडवांटेज ना, दैट्स अ सीन। सीन नहीं पूछा है, एडवांटेज पूछा। एडवांटेज दूसरा क्या होगा? अभी के लिए नहीं, खत्म नहीं करते हैं, फिर डिसएडवांटेज पे जाएंगे। लिखने दे मेरे भाई। Human rights. अब आते हैं डिसएडवांटेज पे। अबे बोल्ड पे क्लिक कर रहा। हाँ कीबोर्ड ये से मारा। डिसएडवांटेज क्या होगा? मिसयूज ही मेरे को एक डिसएडवांटेज याद आया।
ओ भाई तू स्ट्रीम कर रहा
हाँ स्टैंड चाहिए था क्या? क्यों कल नहीं यूज हुआ?
कल वो बोर्ड नहीं लगा के गया था, आज वो लगा के गया।
हाँ
कब तक होगा था?
ये तो 11-12 तक चलेगी।
इतना लेट
खत्म करने का है ना कोर्स।
क्या कर रहा है?
ये ओपन इलेक्टिव।
सबको बड़ा था कुछ
नहीं मैं कंटाल रहा था ऐसे ही, तो मैं स्क्रीन चालू कर देते।
ट्राई करना, कुछ और जुगाड़ तो भी ट्राई करना यार, तो फिर वो
हाँ तो लेके तो जा, स्ट्रीम तो उसके बिना भी हो जाएगी।
वैसे नहीं तो खुद का फेस कैसे दिखाएगा?
अरे तो ये तो इतना भी वो नहीं है, इतनी भी हाइट नहीं चाहिए मेरे को।
ट्राई कर ले एक बार, देख।
ये रहा देख। थोड़ा पीछे रख दूंगा और तो क्या ही। हाँ आ तो जाएगा ही।
पक्का
हाँ ये
हो
देख।
जाता है ना, मैं लेके जाता हूँ,
हाँ
ठीक है ना?
रुकावट के लिए खेद है। ये तो होती तो सर। ओके 140 characters. अरे अभी भी 140 कैरेक्टर्स से ज़्यादा है। ये हटा देते हैं पूरा। सेव ड्राफ्ट अब तो हो गया। हाँ चेक तो प्ले कर हो गया। सबमिट सबमिट। अब फोर्थ हो गया तो इससे पहले एक दूसरा वो काम करना पड़ेगा। ये चैट पे लिख सकते थे आप, वो ज़्यादा जल्दी पढ़ लेता। ज़्यादा जल्दी है। Where is that Coursera? हाँ निंटेंडो तो मिल ही नहीं रहा, उसका सिर्फ चार्जर पड़ा है। वो शायद हॉस्टल पे ही है प्रॉब्लम।
लेके आया था भाई,
मैं लेके आया था।
मैं नहीं लेके आया, उसका थोड़ी तो लेके आया।
तो मेरे को मिल नहीं रही है, कहाँ पे रखी है मेरे को याद नहीं है।
मिल जाए ना तो फिर बोलना, हर जगह कोई नहीं।
हाँ ये रही।
चार्ज करनी पड़ेगी।
हाँ ये लेके जाते हैं।
कोई लेने का स्ट्रीम
है ना, 2 लोग हैं। ये
नहीं होगी चार्ज?
नहीं चार्ज नहीं
मारियो
है।
तक की? अरे मारियो
और ये मारियो की वो इसमें है।
सीधी इसमें होगी।
नहीं इसमें है कार्ड उसका, मैं निकाल के रखा था, इधर नहीं है। अबे कहाँ रखा था मैंने? नहीं मैं निकाल के रखा, तो याद है। आई गेस रुपया तो याद है कहाँ रखा है मैंने। ये क्या दब गया? F5 से क्या होता है? हाँ
वो महंगा पड़ेगा भाई, 200 रुपए का वायर आता है लैन का। कौन सा लैन का? वहां से यहाँ खींचो। हाँ लेटेंसी होती है। ये ले
इसका कवर नहीं है। डिनर भी लेके
स्क्रीन बंद कर देगा। तो
डिनर नहीं करेगा, नहीं खाता नहीं है। थोड़ा पीछे शिफ्ट करना पड़ेगा। भाई माइक म्यूट कर रहा मैं, ASMR बहुत ज़्यादा हो जाएगा नहीं तो। खाना खा रहा हूँ।
What would happen if the death penalty just disappeared in the U.S.? The government could continue executions of the roughly 3,000 inmates currently sentenced to death, or retroactively sentence them to life without parole instead. From a financial standpoint, this would make a lot of sense. Death row inmates require stricter security that costs more money. And since prisoners can remain on death row for decades, that adds up. States would also save money on prosecutions. Death penalty cases can cost up to 10 times more than others. So it's cheaper. But shouldn't serious criminals pay the ultimate price? Perhaps. But since 1973, more than 150 people on death row were eventually found innocent. Prisoners wait years, even decades, for execution, not knowing when or if it will come. And recently, changes in drugs used for lethal injection have resulted in gruesomely botched executions. Some prisoners have chosen not to appeal their cases to shorten the time they have to spend on death row. But doesn't the death penalty deter crime? Actually, murder rates in states without the death penalty have remained lower than states which have it. The death penalty is also disproportionately applied to minority offenders. So, no death penalty might mean a little more equality in the justice system, a lot of money saved, and more time for prosecutors to try other cases.
32 states still execute their prisoners, and lethal injection is the poison of choice. But European countries who abolish the death penalty and
We're back with Jennifer Thompson, the founder of Healing Justice. We're also joined by Clarence, Nancy, and Ricky, who were all convicted of crimes they didn't commit. Mark Godsey is, of course, the co-founder of the Ohio Innocence Project that helped set them free. We're also joined now by legal analyst Ariva Martin in our audience because, Mark, on the legal side, you've gone from prosecutor to trying to get people wrongfully accused out of prison. You all have experience with this, but Ariva, I want to ask you purely for everyone watching right now who's saying, oh, I guess we understand how it can happen, but how can things go so wrong when it comes to convicting the wrong person?
Yeah, Travis, one of the things that happens most often in these wrongful conviction cases is false identification, where someone makes a false identification. I think that's what happened in Clarence's case. He said his 6-year-old niece thought Uncle Clarence did it. And she believed that he was the perpetrator, and the police run with that. So that's one thing that can go wrong. And we heard about cross-identification when you have a white person identifying an African-American. If I see a black person, I know that she doesn't look like the other black person that I see, but when white people and people of different races see people, ethnic people, they often think they look alike. Not intentional, but just how the brain is wired. So we know more about that now. Then there are things like coerced confessions. We heard in Ricky's case that the young man was 13 years old, and he tried to recant his story, but there was coercion by law enforcement to make him stick to that story so that they could get a conviction. There are things like prosecutorial misconduct, where the law enforcement that's investigating the case, they engage in misconduct. So there's just a myriad of things that can go wrong, that can lead to the wrongful conviction of people. But the good news is, people like Mark doing God's work, those innocence projects are so important, so important. And as a result of innocence projects, now a lot of district attorneys' offices have integrity, public integrity units in their own departments where they're looking at cases where their own prosecutors have made mistakes and have wrongfully convicted people. And they're going back on their own, asking that cases be reopened and reevaluated. So not where we need to be in this country in terms of incarcerations, but making some progress.
I think, Mark, also you brought to light some of the almost game-like mentality of some of the prosecutions.
Yeah, I mean, I recognize some of the things that I've seen in their cases because I used to be a prosecutor, and the reactions that the police and prosecutors have, and the mentality of after a while you start going through the motions. It's sort of like you're playing a game. It's all monopoly money. It's not real, and it comes about winning. And the human tendency to jump to conclusions and then latch onto those and sort of get tunnel vision, police officers and prosecutors, and they don't see the other evidence that might suggest innocence.
Not necessarily coming from a place of malice,
right.
Just maybe ignoring things that would potentially exonerate someone that don't fit their story.
Yeah, one of the things that's come out of this whole movement is just a better understanding of how human beings fail and the mistakes we make and sort of the blinders we put on. And so I think psychology has
Fourth lecture on hot topics in criminal justice. Today we're going to be talking about the death penalty. You may remember our first lecture we talked about mass incarceration and its causes. In the second lecture we talked about how we might be able to reduce the rates of incarceration, especially in the United States. And in the third lecture we talked about the nature of criminal responsibility. Today, when we talk about the death penalty, we're going to talk about topics that are very closely related to the first three lectures, because the death penalty is the product of our attitudes towards criminal punishment and our attitudes towards criminal responsibility. So when we're talking about the death penalty, we're going to be focusing on how it works in the United States. We're going to focus on the process of the death penalty and the process of criminal justice generally, with all of its flaws, because it's the flaws in our criminal justice system. It's mistakes that our criminal justice system makes that has a lot to do with why the death penalty is so controversial today. So let's start with a little bit of history. In the first video you watched, you heard that at the time of the drafting of the Constitution, the death penalty was very common. But in 1972, the Supreme Court held that the death penalty was unconstitutional, struck down the death penalty in those states that had it, on the grounds that the death penalty was cruel and unusual. Now, the justices gave a number of different reasons for why the death penalty was unconstitutional, was cruel and unusual, but the main reason was that it was irrational and arbitrarily applied. It was applied in an arbitrary fashion. So the death penalty disappeared for 4 years, but by 1976, a number of states had revamped their death penalty statutes to try to avoid the arbitrariness that the Supreme Court had talked about in its 1972 decision. And what they did is what you see here. The modern death penalty statutes we have with us today identified aggravating circumstances and mitigating circumstances, all in an effort to try to control and guide juries in the decision-making about the death penalty. What are aggravators? As it shows here, aggravators are factors that makes the crime more serious. For instance, if it's an aggravator if the defendant has committed other offenses in the past. It's an aggravator if the individual is considered particularly dangerous. Those are the kinds of factors that push in the direction of assigning the death penalty. Mitigators are factors that mitigate a person's culpability. For instance, mental disability, or perhaps the fact that the individual has no prior crimes, or the fact that in the course of the crime, the individual was a follower as opposed to the leader of the criminal group that engaged in the crime. So that's what the modern statutes that describe and define the death penalty do today. And they've been upheld as constitutional. But there are other restrictions on the death penalty. The Supreme Court has said that only the worst of the worst may be put to death. Now, what has that meant? Well, first of all, only people who commit murder may be put to death. So even if a person commits a horrible rape, even a person commits horrible armed robbery, those people cannot be put to death. They can be sentenced to very long terms of imprisonment, but execution is off the table. And within the group of murderers, only the most culpable murderers, only the worst of the worst may be sentenced to death. So how do we figure out who is the worst of the worst? Well, the Supreme Court has held that at least one of those aggravators that I described a little bit earlier has to be proven beyond reasonable doubt. And the aggravator or aggravators that are proven by the prosecution have to outweigh the mitigating circumstances. If that happens, then the death sentence can be imposed. But if the mitigators outweigh the aggravators, the death sentence may not be imposed. And usually the alternative sentence that the jury is given is life without parole. The jury is given the discretion to impose life without parole as an alternative to the death penalty. The Supreme Court has also said that in this category of worst of the worst, we may not include people who are under the age of 18 who kill and people who have intellectual disability, a phrase that refers to people who used to be called people with mental retardation. Why did the Supreme Court hold that? Because the Supreme Court said that people who are under the age of 18 are too immature to be fully culpable. They just are not the worst of the worst. And the same thing goes for people with intellectual disability. Because of their low IQ, they cannot be, under any circumstances, the worst of the worst. Even if they intentionally kill, they cannot be sentenced to death because they're not in that category of people that deserve the ultimate punishment. So that's a survey of death penalty law. And about 30 American states still have the death penalty using statutes of the type I just described. 20 states do not have the death penalty, but about 30 do. The first video said 32 states, but since that video was made, 2 states have gotten rid of the death penalty. So today we have 30 states. About 10 of those states haven't executed anyone for the last 10 or 15 years. But the death penalty is alive and well in at least 20 states. And you see from this map that the United States is the only country in the West that still has a death penalty. The countries in red are the countries that have the death penalty. So the United States has the death penalty. China, India, several countries in the Middle East and Africa have the death penalty, but no other countries do, at least a robust death penalty. Why is that? Why is the United States one of the few countries that has the death penalty and the only country in the Western world that has the death penalty? Well,
हो गया, डिनर हो गया भाई। लोग ये जो 2 लोग देख रहे हैं कब से भाई, तुम लोग रियल सपोर्ट है, थैंक यू।
Well, in the first lecture, we talked about some of those reasons. If you remember, we talked about America's populism, which tends to take a knee-jerk approach to increases in crime, tends to result in relatively harsh punishment. Also, the idea that outside of cases involving insanity, people are responsible for whatever they do. We have the concept of evil in the United States, and it plays a very strong role, and it creates a culture of punishment here in the United States. And finally, there's the issue of race and this fear of the other that we talked about during the first lecture. So all of those factors can contribute to the relatively punitive culture we have in the United States and may help explain why we have the death penalty in the United States. But those are cultural explanations for the death penalty. What about theoretical reasons? Policy reasons for the death penalty, separate and apart from culture. What do legal theorists say are the rationales for the death penalty? Well, you remember from the first and second lectures, we talked about 3 different purposes of punishment. We talked about deterrence as a purpose of punishment. We talked about individual prevention as a purpose of punishment. And we talked about retribution as a purpose of punishment. So how do those theories help explain or not justify the death penalty? Well, there is some research about the deterrent effect of the death penalty. And according to the National Academy of Sciences, the research is as at best mixed. It's at best mixed. In other words, states with the death penalty do not have any lower crime rates than states that do not have the death penalty. And in fact, some research suggests that the death penalty may actually increase crime rates because it tends to brutalize the society in which it's applied. But in any event, the bottom line is the deterrent studies suggest that there's no clear deterrent effect to the death penalty. What about individual prevention? Clearly, if we execute someone, they're not going to be able to harm anyone else. That is a very efficient way of preventing an individual from harming someone else. But of course, there is an alternative to the death penalty in terms of protecting the public, and that's sentences of life without parole. If a person's put in prison for their entire life and not given the opportunity to obtain parole, they also are kept off the streets. Now, of course, they could threaten other prisoners or guards, but they won't threaten the general public. And in fact, when people are asked, would you prefer the death penalty or life without parole? We see a majority of people saying they prefer life without parole. They seem to think that's sufficient protection for the public. In other words, when people are asked, would you prefer the death penalty or no death penalty, a majority of the public says they prefer the death penalty. But when they are asked, do you prefer the death penalty, when the alternative would be life without parole, support for the death penalty goes well below 50%. So it suggests the individual prevention goal is not necessarily the best reason for the death penalty either. That leaves retribution, the idea that some people simply deserve the death penalty. They've done something so evil, so bad, that the death penalty is the only possible penalty for them. And of course, this is expressed in the biblical expression, an eye for an eye. So this is the justification that's most often trotted out for the death penalty. And it might be a justifiable reason for the death penalty, again, in cases involving the worst of the worst, the most evil individuals. I'm not going to say anything more about the moral justification for the death penalty. I'm going to assume from now on that there are some circumstances where the death penalty may be justified. What I want to focus on now is how the death penalty works in practice. Okay, how does it actually...
लिख लें दो थोड़ा। वाईफाई स्पीड प्लान तो 40 Mbps का है, मिलती अराउंड 20-25 है, 28-30 ऑन अ गुड डे। अभी जैसे मैं लैंड लगा रखा है तो अच्छी मिलेगी, 30 के आसपास मिलेगी, बट रियलिस्टिकली 10 Mbps मिल जाए मोर देन एनफ। अच्छी है, हाँ बहुत अच्छी है। अगर मिले 50 Mbps तो भाई क्या ही गए। यहाँ पे ना थ्रूपुट का कोई वो नहीं रखते, देख तो मैं तो समझा देता हूँ। एक चीज़ होती है बैंडविड्थ, एक चीज़ होती है थ्रूपुट। अब बैंडविड्थ जो होती है, जो 50 Mbps 40 Mbps 100 Mbps जो मार्केटिंग करते हैं कंपनीज, वो होती है बैंडविड्थ। मतलब बैंडविड्थ मतलब कि अगर अकेला तू है उनका इंटरनेट वापरने वाला और तूने लैंड लगा रखा है, ये वायर्ड कनेक्शन है तेरा कंप्यूटर का और सर्वर का डायरेक्ट, तो तेरे को जो स्पीड लिस्टेड है, जो बैंडविथ है 50 Mbps की, वो मिलेगी। बट ऐसा तो होता नहीं, हज़ारों लोगों का कनेक्शन होता है एक ही सर्वर से, तो 50 Mbps बैंडविथ होती है, लेकिन वो डिस्ट्रीब्यूट होती है। और ऑब्वियसली काफ़ी लोग वाईफाई यूज़ करते हैं, मोस्ट ऑफ देम यूज़ वाईफाई, और वाईफाई में मीडियम ऑफ ट्रांसपोर्ट एयर है, तो एयर में काफ़ी सारी डिस्टर्बेंस होती है, जबकि तू लैंड लगाता है, वायर लगाता है, तो उसमें बहुत कम डिस्टर्बेंस होती है, क्योंकि डायरेक्ट जा रहा, बीच में कोई ऐसा हवा नहीं है, समझा, वैक्यूम से जा रहा। और जितनी देर को एक्चुअल स्पीड मिलती है उसको बोलते हैं थ्रूपुट हमेशा कम ही होता है बैंडविड्थ से। तो जितना इंटरनेट सर्विस प्रोवाइडर बोलते हैं ना, सपोज 50 Mbps का प्लान बोल रहे हैं, तो तू 20 मान के चलते को, जब कम लोग यूज़ कर रहे हैं, ऐसे टाइम होते हैं जैसे रात को 2 बजे 3 बजे इतने लोग नहीं यूज़ कर रहे होते जितने लोग दोपहर को 2 बजे 3 बजे यूज़ कर रहे होते हैं, समझा। तो देखो दोपहर में कम स्पीड आएगी, रात में ज़्यादा स्पीड आएगी, समझा। तो रात में मान के चलते को अगर 50 Mbps का प्लान है जियो का या GTPL का डलाता है, तो तेरे को 20-25 के आसपास आएगी स्पीड, और दोपहर में एक्सपेक्ट 15-20 Mbps, 15 Mbps। यही था मोटा मोटा।
Function on the ground. In order to do that, we're going to talk about the state of Florida, where we know a whole lot about how the death penalty functions. So when we come back, that's what we're going to focus on, is how the death penalty works in practice. But first, are there any questions about what I've said so far before we take a break? Yes.
For the aggravating and mitigating factors, are there certain ones that are given more weight than others, typically?
Typically, yes. One I did not mention is if the murder is committed in a particularly heinous fashion. That is, torture is involved, perhaps multiple stabbings, cutting off limbs. Unfortunately, there are cases involving those kinds of conduct, and that is a particularly powerful aggravator. Prior criminal history, though, of course, is also a very powerful aggravator. Interesting enough, mental disability, even though it's supposed to be a mitigator, sometimes apparently is treated by jurors as an aggravator. Why? Mental disability is sometimes associated with dangerousness. And so even though it's supposed to be a mitigator, it sometimes ends up being an aggravator, which puts defense attorneys in a very difficult position. Do they raise or do they present evidence about mental disability in the hopes of mitigating, or do they not raise it out of fear it'll be treated as an aggravating circumstance? Any other questions? Okay, we'll take a break.
प्रैक्टिस क्विज लेगा।
And we're going to focus on the state of Florida because there's been quite a bit of research on how the death penalty works in the state of Florida. And I want to start by talking about the economics of the death penalty. As one of the videos indicated, the death penalty is a very expensive proposition. It can cost a lot of money to adjudicate capital murder cases, then figure out whether the person deserves a death sentence. And then if the person is given a death sentence, all of the litigation, the appeals, and so on that take place afterward can be very expensive. So in Florida, for instance, it can cost $2.5 million more to carry out a death sentence than it costs to carry out a 40-year sentence of life. Okay, a life sentence of 40 years. So in other words, death sentences and the death sentencing process is much more expensive than a life sentence, even though you think the opposite. And again, it's because death sentence trials and sentencing proceedings take a very long time, and because the appeals process can be very prolonged. In California, it can cost over $250 million a year more to impose a death sentence on someone than a sentence of life. So again, in other states as well, it can be very expensive. There are other costs to the death penalty. For instance, in Florida, when survey prosecutors indicated that even though they may be in favor of the death penalty as a philosophical matter, they can have significant problems with it in terms of resources. Because what happens in a death penalty case is that the best prosecutors are pulled away from other cases and required to prosecute the death penalty cases, because those are the most important cases. Those are the cases where most is at stake. So in other words, the death penalty sucks resources from the rest of the system and can limit what can be done with respect to non-capital cases. And another cost in the state of Florida is that even though only 3 to 5% of all criminal cases involve capital crimes, 50% of the Florida Supreme Court's docket involves capital cases. Why? Because every death sentence case has to be appealed to the Florida Supreme Court. It's required to make sure that the death sentencing process is consistent. That's another one of the expenses. That's another reason things take so long. So that's the economics of the death penalty. But there are other costs as well. As the third video made very clear, one incredibly significant cost is that innocent people can be convicted of capital murder. Innocent people can be sentenced to death. And that's what I want to focus the rest of this talk on, is why we can have a situation where people who are innocent of any crime are not only convicted, but convicted of capital murder, and not only sentenced, but sentenced to death. How can that kind of thing happen? Well, that gets us into how the criminal justice process works in the state of Florida and everywhere. So let's talk about the state of Florida first. Florida has over 400 people on death row. It has executed roughly 70 people since 1976. And it experiences about 38 death sentences a year. So that's Florida in a nutshell. But the stunning thing about what's going on in Florida, at least from the perspective that I just mentioned, is that since 1976, 22 people have been exonerated. That's about 5% of the people on death row have been found to be totally innocent of the crime for which they were convicted and sentenced to death. Now, that's a very scary statistic. And that's probably not everyone who deserves to be exonerated. Those are the people who have been discovered to be innocent because witnesses recanted or DNA has cleared them of the crime for which they were convicted and sentenced. So why does this happen? Why does this happen nationwide? There have been over 200 exonerations across the country in terms of death sentences, and 2,000 exonerations if you count all crimes, not just capital crimes, but non-capital crimes. That's a very significant statistic. What's going on here? Why are we convicting innocent people? Well, there are lots of reasons. They're up here on the screen. I'm going to talk about all 5 of these reasons, and I'm going to talk about ways we might be able to prevent, or at least inhibit, the kinds of flaws in the system that you see up here on the screen. Let's start with confessions. Surprisingly, there are a large number of what are called false confessions. These are confessions by people who did not commit the crime to which they confessed. Now, how in the world can that happen? Well, to some extent, this happens because the person who confesses is young or mentally disabled and perhaps a little confused by the process. But we also have many cases where the individual who confesses is not particularly young, is not mentally disabled, and yet we get a confession from such a person. How can that happen? Well, as the slide suggests, sometimes the interrogation process can be very coercive. And of course, one problem with coercive confessions, coercive interrogations, is that if a person feels coerced, they might say anything in order to avoid the coercion. They might actually confess to something they didn't do if they're feeling coerced. Yeah. Now, you've all heard about Miranda. Everyone in the United States knows about the Miranda decision. A person's given the warnings about the right to remain silent, and then you say maybe used against you having the right to an attorney. And that alleviates the coercion that's inherent in interrogation to some extent. But interestingly enough, the warnings are almost always given before most interrogations. And despite the fact people are given these warnings, despite the fact people are told they have a right to remain silent and they have a right to counsel, they usually end up talking without counsel present. 80% of the people given warnings end up talking. So the issue in most interrogation cases is not whether Miranda warnings were given or not. It's whether after the Miranda warnings were given, was the confession given voluntarily, or was there coercion during the interrogation process? That's the issue. And as I'm about to demonstrate, coercion is defined very narrowly. Essentially, the courts are focused on whether there was physical coercion. That is, whether there was torture, which is very, very rare, or whether there was some other kind of physical coercion imposed on the individual. Mental coercion is simply not considered coercion by most courts. So let me give you some examples out of the state of Florida. Again, we're focusing on Florida. These are 4 Florida Supreme Court opinions. In Chavez versus State, Chavez was interrogated for 54 hours. 54 hours with 1 6-hour rest period. So otherwise, no rest whatsoever during the 50-hour period. In Nelson versus State, Nelson was subjected to 2 all-night interrogations with just 3 breaks during the second all-night interrogation. In Walker versus State, the interrogation was only 6 hours long, but Mr. Walker was threatened with the electric chair and then promised that if he confessed, he wouldn't have to worry about the chair. And then finally, in Davis versus State, Davis was told that the situation would get much worse for him if he did not confess. Now, none of those cases involved physical coercion. Right? There wasn't a baseball bat hovering over the person's head. But I think many people would say what went on in these cases was mentally coercive. Long interrogations with very long durations that either had no breaks or very few breaks. Threats of the electric chair, or threats suggesting the situation would get much worse if the confession was not forthcoming. Those are situations where I think many people would say there was mental coercion, but the Florida Supreme Court found no coercion in any of these cases, no unconstitutional coercion in these cases. The confessions in all of these cases were admitted into evidence. Okay. Now, can I say that any of the confessions in these cases were wrong, inaccurate? I can't. These people have all been sentenced, and they have not been released from prison. However, Florida does have 5 exonerees who were convicted based on confessions that turned out to be incorrect, that turned out to be false. In some of those cases, the people did have mental disability. In other cases, the people did not. Okay, so this can happen. We can get false confessions that not only lead to conviction and sentence, but conviction for capital murder and the death penalty. So what can we do about this? Well, there are lots of possible ways of trying to prevent coercive interrogations. One is to videotape interrogations. What would that do? It would allow lawyers and judges to see precisely what went on during the interrogation. It also would remind police there's a camera on them at all times, and that might inhibit particularly bad misconduct by the police. We can also train the police better. And here I'm referring in particular to training police about how to handle people with mental disability, how to handle people who are young, because those people are very suggestible. If they have an authority figure in front of them, they're very likely to say whatever they think that authority figure wants them to say, even when there's not very much coercion. So there needs to be training in those kinds of situations in particular. And then we just need to have more restrictions on how interrogation is taking place and on how interrogation is carried out. Here is a statute that's on the Florida statute books. As you can see here, it puts quite a few limitations on interrogation in Florida. It says the questioner may not use offensive language, cannot threaten negative consequences, so the type we saw in some of the cases I described earlier. Interrogations must be limited to reasonable periods. They can't go on for 54 hours with no breaks. And the person must have personal necessities and rest periods. And interrogators can't gang up on the subject. There can only be one interrogator at a time. And interrogations have to be taped in their entirety. Those are pretty good rules. They probably would take care of a lot of the problems that I just got through describing, but they don't apply to the typical interrogation. What kind of interrogations do they apply to? Interrogations to police. Those are the only kinds of interrogations this statute applies to. Why? Police unions were worried about unfair interrogations of members of their union. But you know the point I'm going to make. If the police think this is what needs to be done when they're interrogated, doesn't this also apply to subjects who are not police, who are charged with crimes of the type we're talking about? I think these are very reasonable restrictions. They do not prevent interrogation. They just put limitations on them. And these are arguably the kinds of rules we should have in interrogation. So, any questions about what we've talked about so far? Seeing none, let's take a break. When we come back, we'll talk about a second cause of wrongful convictions, inaccurate.
Okay. Sure. ओके ये चलता है, ये भी चलता है। ओह अच्छा, ओके सब चलता है। वाह, ट्राई अगेन। किस तरह से टॉर्चर नहीं चलता है। ओके वो सबके लिए है, वो खाली उसके लिए, पुलिस इंडिविजुअल्स के लिए, अथॉरिटीज के लिए। इतना annoying है ना इसका intro.
We're now going to talk about what is probably the most significant cause of wrongful convictions, inaccurate eyewitness identification. 5 of the people who have been released from death row in Florida were convicted because of eyewitnesses who identified the wrong person. This identification in the courtroom of the defendant by an eyewitness is extremely powerful evidence, because you can imagine how it happens. The witness is on the stand, the prosecutor says, can you see the perpetrator of this horrible crime in the courtroom? And the witness points right to the criminal defense sitting next to the defense attorney. Very powerful evidence, and it's even more powerful probably because the eyewitness really believes that the person they're pointing to is the culprit. The eyewitness is not lying. The eyewitness really does believe this is the person who committed the crime. And yet 5 times, just in capital cases, the eyewitness was dead wrong, as proven by DNA or some other kind of evidence. So why do we get incorrect eyewitness identifications? Well, there are lots of reasons. Some of them are obvious, right? At the time of the crime, there wasn't very good lighting, or the perpetrator was a long way away, or the eyewitness has bad eyesight. But there are other reasons that are a little bit more subtle. Contrary to common wisdom, a stressful event does not make you more perceptive. A stressful event actually impairs your cognition. You're not as accurate at perceiving what's going on in front of you when you're under stress, especially when you're looking at a weapon. There's a lot of research on this. It's called weapons focus. Not surprisingly, you tend to look at the weapon, as you're probably doing right now, as opposed to the face behind the weapon. So your description of the gun might be great, but your description of the face of the perpetrator might not be as good. And then, of course, we have cross-racial identification problems. Study after study has shown that it's much more difficult to identify a member of the opposite race than it is to identify a member of your own race. So those are some of the problems with eyewitness identification. And it gets worse, because your perception can be influenced by your biases. Probably a lot of you have favorite football teams or some favorite sports team. How many times have you been sure the ref has muffed a call, has called a penalty when it shouldn't have been called, and then on instant replays, oh, you know what, the ref was right about that. Why might that happen? Because you figure that any call against your team is wrong. That's your preference, that's your preconception, that's your bias. So you're going to be predisposed to disbelieve a penalty imposed on your own team. That's something that can happen during eyewitness of a crime as well, eyewitnessing of a crime as well. So that's one problem. Another problem has to do with memory. Your perception can be bad for all the reasons we talked about. Your memory can also be bad. Let's assume you perceive the crime completely accurately. You don't have any lighting problems, your eyesight's perfect, there's not a lot of stress associated with the crime, or maybe there's no guns, you're not focusing on that, it's not a cross-racial identification. None of those problems exist. Unfortunately for all of us, your memory starts deteriorating immediately. Even if you have a totally accurate perception within minutes, not just within hours, your memory starts deteriorating. How many times you've ordered something from a waiter in a restaurant, you've looked right in the waiter's face, and then 5 minutes later you can't remember what your waiter looks like. That's your memory falling apart. I know it's happened to me, maybe it hasn't happened to you, but I think it's happened to a lot of people. Right? Especially since they're all wearing the same uniform, you tend to forget what your waiter looked like. Well, that's memory failing you. And these perception and memory problems can have very significant impacts. So let's take, I've already talked about perception to some extent. Let's talk about memory. If your memory is deteriorating, if you can't quite remember exactly what happened, what happens? Well, very often your mind plays tricks. It starts replacing memory used to have with what you think probably did happen, based on your preconceptions, based on your biases. You're replacing the real memory with a memory that's based on what you think probably did happen, based on your experience. There's a very famous study involving a subway. It pictured a man with a knife threatening, or at least pointing a knife towards another person. In the picture, the man with the knife was white. The man who did not have a knife was black. But when people were asked to describe that picture sometime later, quite a few of them said the man with the knife was black and the man without the knife was white. What was going on there? The memory deteriorated, and they're replacing that memory with preconceptions about what probably did happen. That's a very real problem when you get eyewitness identification. You can have significant accuracy problems because of the fact that memory starts deteriorating. So, it's also important to recognize, however, that police and courts have nothing to do with perception and memory problems. It's not their fault that a person's perceptions might not be accurate, that a person's memory starts deteriorating. But police and courts can nonetheless exacerbate the problem in a number of different ways. First of all, they can use what are called suggestive procedures. So the most obvious example of a suggestive procedure is they put the suspect in a lineup of 4 or 5 people who look nothing like the suspect. It's called a sore thumb lineup. The suspect's the only one that looks anything like the suspect or the alleged perpetrator. Or another example of suggestive procedure is where we don't have a lineup or a photo array involving 5 or 6 people or 5 or 6 photos. We have one photo or a one-on-one confrontation. That's extremely suggestive. It's basically saying to the eyewitness, this is the person, right? This person I'm showing you right now, or this one photo I'm showing you right now, this is the person. That's extremely suggestive. Arguably, police should avoid that kind of procedure. And then police also, even if they conduct a lineup in a way that's not a sore thumb way, that is, they have a lineup that has individuals who look like the description of the perpetrator, police can consciously or unconsciously suggest the right result. So, for instance, let's say we have a lineup with the eyewitness on the other side of the one-way mirror, which is the way it's usually conducted. I'm sure you've seen that on TV. And the eyewitness is saying, well, I'm not sure. I don't know if it's 1, 2, 3, 4, 5, or 6. The cop might say, well, look really closely. Come on. The person's got to be there. Maybe, at worst, the cop will say something like, look closely at number 3. What about that one? Now, hopefully police don't usually do that, but you can see just by saying look more closely, there's pressure being put on the eyewitness to identify someone. Even if the eyewitness is not certain, the eyewitness might end up pointing out someone, and that, of course, can result in a wrongful identification. And the real problem here is that once a person has been identified, what happens to the eyewitness's memory? That person now becomes the perpetrator. From then on, that's the perpetrator, because that is the face that's burned into the eyewitness's mind, in the eyewitness's memory. Yeah. Unfortunately, in the state of Florida, there are very few policies preventing the kinds of suggestive procedures that I just got through talking about. In fact, in most police departments, there are no policies that prohibit those kinds of conduct. And the courts also are complicit in this, because what the courts will do is say, even if there was a suggestive procedure that creates some of the problems I'm talking about, so long as the witness is willing to say that the identification in the courtroom rests on a memory that's independent of anything that happened pre-trial, is independent of the pre-trial identification, then the in-court identification will be considered admissible. Well, I hope you can see what the problem with that is. What is the in-court identification actually based on? Is it actually independent of the pre-trial identification? Probably not. Research tends to show us, as I've been suggesting, that once during the pre-trial process someone's identified, that's going to be the memory that's etched in the eyewitness's, that's going to be the image that's etched in the eyewitness's memory. And that's going to be why the eyewitness points out the suspect in the courtroom. It's not going to be based on independent memory, but rather a memory that's tainted by the pre-trial identification. At least that's the concern. And yet the courts routinely apply this independent recollection doctrine to allowing in-court identifications. So, what can we do about all this? Well, some of it's pretty obvious. And luckily, there are a number of suggestions for best practices. Best practices for carrying out identification procedures. And here are some of them. First of all, avoid one-on-one confrontations. Avoid having the situation I talked about earlier where the officer brings one person to the eyewitness and says, this is the person, or one picture, and shows that to the eyewitness. Avoid those kinds of situations. If you do a lineup or a photo array, make sure you have 5 or more people in the lineup or photo array to give the eyewitness several choices. And this is interesting, make sure that the foils, that is the people who are not the suspect, match the description of the eyewitness. In other words, you're not looking for people who match the suspect, because you're not trying to figure out who the police have arrested. You're trying to figure out who the perpetrator is. So you want to get foils that match the description the eyewitness gives, which hopefully is given to the police before they set up the lineup. And the foils should simulate that description. And finally, avoid repeated identification attempts. In other words, if the eyewitness does not identify anyone during identification procedure, a lineup or a photo array, don't do another one with the same suspect in the lineup or the photo array, because you know what's going to happen. Okay? The eyewitness is going to say, wait a minute, I've seen number 3 before, but where will they have seen number 3 before? Conceivably during the previous lineup as opposed during the crime. That's the problem with repeated identification procedures. Yet police do this all the time. Why? They don't get an answer the first time. They want to do it again to see if they can get a better answer. These are other recommendations. If there's more than one witness to the crime, keep them separated. Make sure they don't influence one another, because that can happen, right? If witness number 1 says, oh, it's number 3, witness number 2 is likely to say it's suspect number 3 as well. Blind administration, what does this mean? The officer conducting the eyewitness identification procedure should not know who the police suspect is, should have no idea. That avoids any unconscious or conscious suggestion by the individual running the procedure. This is very important. Offer a blank choice. Tell the eyewitness, you know what? The perpetrator might not be in the lineup. The perpetrator might not be in this photo array. In fact, in photo arrays, if there's 6 photos, there should be a choice number 7, a blank, which indicates the person might not be there. This is important because the eyewitness needs to know the perpetrator might not be there. And that avoids putting pressure on the eyewitness to identify someone as the perpetrator. And finally, videotape everything. So the police know they're being videotaped, so lawyers and judges can see how the process was carried out. So those are 2 reasons why innocent people might be convicted. An interrogation process that's coercive in the sort of ways that I've been talking about, and suggestive identification procedures. I'm going to stop here. We'll talk about some other reasons why there might be wrongful convictions in a second, but I'm curious if anybody has any questions about what I've just got through discussing. Yes?
For the identification issues, are there anything that defense attorneys can do now to kind of combat those?
Sure. Defense attorneys ideally would be present during the identification procedure. And they could point out if the best practices I just got through describing are not followed. Hey, there are only 4 people in that lineup. Hey, you have all 3 witnesses here in the same room, and they're going to influence one another. Defense attorneys can certainly object, but the law as it stands right now says defense attorneys cannot prevent suggestive procedures from taking place. All defense attorneys can do is try to prevent them, make suggestions to the prosecutor. And then if those suggestions are not followed, argue in court, Your Honor, I made suggestions, those suggestions were not followed. I think the procedure as implemented was suggestive, and therefore the identification should be excluded. But of course, the prosecutors can argue independent recollection, and if that argument wins, then an in-court identification will be admitted, even if the pretrial identification is excluded. But certainly that's something the defense attorney can do.
At trial, even after they've addressed those concerns with the judge, are they allowed to say to the jurors that this was a suggestive procedure?
Very good question. Yes. Even if the defense attorney is unsuccessful at preventing the suggestive procedure in the first place, unsuccessful at getting the pretrial identification or the in-court identification excluded, the defense attorney can always argue to the jury everything I've been talking about. Can even put an expert on the stand and recite the research that I've been alluding to in the last several minutes to try to get the jury at least to think, have second thoughts about the confidence that the eyewitness has evidenced in pointing out the defendant as a culprit. And one piece of research I didn't mention, which is interesting, is that there's almost an inverse relationship between the confidence an eyewitness has as to who the perpetrator is and accuracy. Now I say almost an inverse relationship. It's not quite an inverse relationship, but given what I've been saying, you can see how it might work. If an eyewitness is extremely confident that he or she knows who the perpetrator is, it's conceivable they aren't being humble enough about the problems with perception and the problems with memory. Now that's not always the case. Sometimes an eyewitness is dead sure and they're absolutely right as to who the perpetrator is. But in a lot of situations, because of all the perception and memory problems I've been talking about, an eyewitness who's really being honest with him or herself will understand, I'm not absolutely certain this is the right person. You know, prosecutors don't want the witness getting on the stand and saying that, but if they're going to be honest, that may be the case. In any event, a defense attorney can put an expert on the stand and tell the jury about research that suggests this relationship between confidence and accuracy. Any other questions? Okay, we'll take a break.
Question. True or false? Traumatic events such as crime tend to be perceived accurately because of the stress involved. False. Which of the following are ways police can maximize the accuracy of an identification by an eyewitness? Check all that apply. Blind administration, yes. Provide a blank choice, yes. Sure, there are at least 5, yes. Or repeated, yes. Select someone, yes. Videotape. Police का क्या है videotaping or different witnesses? I'm not quite sure about that one. है क्या? वो रखना पड़ेगा क्या? अच्छा, I didn't select all the correct answers. वीडियो टेप करना पड़ता है क्या? उससे पुलिस का क्या हो? वो तो बाद में प्रोसिक्यूटर्स को हेल्प करेगा, जज को हेल्प करेगा. पुलिस को कैसे हेल्प करेगा वीडियो टेप करना? I don't know, but I guess I believe that's the answer. Oh, that's not the answer. Wait. Man. How does arranging separate procedures for different witnesses allow the police to get a better answer? I don't know. I mean, I'm sure he said that and I didn't pay attention, but how much is left? Oh, it's almost over. Okay. No, it's not. ये इतना ही लिखा बस ये week 4
About 2 reasons why innocent people might be wrongfully convicted. One is the interrogation process. 2 is the identification procedure process. Now we're going to focus on a third reason, and that third reason is that forensic science is not all it's cracked up to be. Despite what you see on TV, forensic labs can sometimes get things wrong, and that's happened in capital cases as well as in non-capital cases. Even DNA, which is considered the gold standard of forensic science, can be problematic for lots of different reasons. Here's one study, which is pretty stunning. A study of 268 cases found that erroneous statements were made in 96% of those cases. In 35 of those cases, the defendant received the death penalty, and 9 of those 35 people have been executed. Now, this is not to say that the people who I just described were innocent of crime. when it describes erroneous statements, those erroneous statements were about anything having to do with the DNA testing. And some of those statements were relatively minor. They weren't necessarily conclusions reached by the technician that resulted in conviction of an innocent person. But nonetheless, it's a little bit concerning that DNA, which again is considered the gold standard of forensic science, is this problematic, has this kind of error rate. And this is true of other kinds of forensic evidence as well. For instance, one study found that in about 0.8% of all fingerprint cases, there's an erroneous misidentification. And that's not a very high percentage, but it works out to about 1,900 mistaken fingerprint matches. And if the prosecutors are relying primarily on a fingerprint match to convict someone, that's 1,900 cases where there might be a wrongful conviction. One study found that overall, bad forensic science was involved in 64% of the cases where an individual was eventually exonerated, that is, let off of death row. So that's a fairly significant error rate. Forensic science is a problem when it comes to accurate convictions. And in Florida, what we had, 3 exonerees who were convicted using bad forensic science. 2 of those individuals were convicted based on erroneous hair identification testimony, and the third was convicted based on erroneous testimony about shaken baby syndrome. Turned out to be expert testimony that was completely erroneous. So 3 exonerees were convicted based on bad forensic science. How can we take care of this problem? The solutions are relatively straightforward. We can make sure that these laboratories are accredited. At the time that the study finding that there were 22 exonerees in Florida was carried out, only 4 of Florida's 24 forensic labs had even sought accreditation. So that's obviously a problem that can be taken care of. These labs need to be accredited. A second possible way of dealing with this, in fact, I shouldn't say possible, mandatory way of dealing with this, is making sure that rigorous protocols are followed. And in particular, that samples not be contaminated. There are a couple of cases involving exonerees in the state of Florida where, yes, the individual's DNA was at the scene of the crime, but it's because he had been at the scene of the crime the day before the crime, not on the day of the crime. What had happened is samples got mixed, and the defendant's sample was identified as the perpetrator sample when, in fact, it was not the sample of the perpetrator. It was the sample of the defendant. The perpetrator sample had been mixed with the defendant's in a way that caused a misidentification. And finally, I shouldn't say finally, this is just one of many possible recommendations, but one I'll emphasize is there ought to be a prohibition on police communicating with technicians that they think the sample comes from the perpetrator of the crime. The reason for that is that if that is said to the technician might be tempted to find a match when in fact there is none. Forensic technicians can be influenced by those kinds of communications just like anyone else can be. So those are some of the things that can be done to help avoid misidentifications based on forensic work. So what I've talked about up until now in terms of causes of wrongful convictions are situations that probably can, if they can't be avoided completely, at least can be reformed to a great extent by some specific rules, adopting specific rules about interrogation, specific rules about identification procedures, and specific rules about forensic work. What I'm going to talk about now are 2 structural problems that are a little bit harder to do something about. The first structural problem is what I'll call adversarialism. This is the adversarial nature of our legal system. Now, as I said during the first and second lectures, adversarialism is part and parcel of the American criminal justice system. We believe that the adversarial approach to truth-finding is the best way to find the truth. We have 2 parties battling one another, each presenting opposing views, or most likely to rival what happened at the time of a crime. And that may be true, but at the same time, adversarialism can have a bad side effect. It can get parties so committed to their point of view that they won't listen to anything from the other side. They tend to have a closed-minded view about the case. And that's particularly a problem when it comes to prosecutors and the police because they have so much power in terms of bringing cases. If you remember the third video, Professor Gotzi talked about something called tunnel vision. What is that? It's the idea that you tunnel in on a particular theory of the crime and nothing can budge you from that. And it's a very human kind of behavior. And once you get a theory, you tend to stick with it. It's sometimes called confirmation bias. Okay, what you do is you seek out evidence that confirms what you already believe, and you tend to ignore or discard evidence that does not confirm what you believe. It's a very real problem for all humans, but it's a particularly big problem if prosecutors or police are suffering from it, because it means they're going to try to find evidence that confirms their bias, that is, that the suspect is the guilty one, and not try to find evidence that disconfirms their bias. So, how does this play out? Well, in Florida, it's played out in this way. In 3 exoneree cases, the prosecutor failed to reveal exculpatory evidence. That is evidence that would have or possibly could have exculpated the defendant. They had it in their files, and they did not hand it over to the defense. This is unconstitutional. There's a constitutional requirement on the part of the prosecutor that if he or she has exculpatory information in their files, it has to be given to the defense. But in 3 of these cases, the prosecutor did not give that information to the defense. And in another set of cases, the tunnel vision was particularly bad, because in this set of cases, the prosecutor not only did not hand over exculpatory evidence, the prosecutor affirmatively presented false testimony in court. In some of those cases, knowingly presenting perjured testimony. Now that's adversarialism taken to its an extreme. You're willing to present false testimony. Now, do I think these prosecutors are evil? Well, maybe I wouldn't go that far. It may be just television at work. You become committed to a particular theory of the case, and you ignore evidence that disconfirms your bias, and you're even willing to use false evidence because you know that false evidence is used in service of getting the guilty person. Even though it's false, it's all with the goal in mind of getting that person who you know is guilty. Well, nonetheless, that's a real problem. As we can see, some of these people who have been convicted using this kind of testimony and have been convicted when exculpatory evidence has not been revealed to the defense have been innocent, have been wrongfully convicted. And the Florida Supreme Court has sat up and taken notice. This is what it said about prosecutors in one of its cases. As we've noted in previous cases, we're deeply disturbed by continuing violations of the prosecutorial duty, propriety, and restraint that the ethical rules require. It ill becomes those who represent the state and the application of its lawful penalties to themselves ignore the precepts of the profession and their office. So obviously the Florida Supreme Court is pretty bothered by what I just got through describing. So what can be done about it? Well, one thing that can be done is reversal of convictions, where the prosecution fails to give exculpatory evidence, where the prosecution uses false testimony. The problem here is the Florida Supreme Court, despite the language you just saw, where it's expressing dismay and chastising prosecutors, it doesn't always reverse convictions when there's a failure to give exculpatory evidence to the defense, when there's use of false testimony. Why? Because sometimes it finds that the error is harmless. It says there's so much evidence against the defendant that the fact that the prosecutor violated the Constitution, violated ethical principles, doesn't matter. The guy was guilty, it doesn't matter that the prosecutor violated the rules. Well, that may or not be true. The error may have been harmless, like the Florida Supreme Court says, but think about what the message is that's sent to the prosecutor. If you've got a very strong case, a case that you think an appellate court will think is strong, don't worry too much about constitutional rules, revealing information to the defense that's exculpatory, perhaps using false testimony, because that error will be found harmless on appeal. That's not a very good message to send to prosecutors. It's not a very strong deterrent message. A stronger deterrent message is to discipline prosecutors who behave in the ways I've been talking about. Take them up in front of the ethics board. At least get a reprimand, perhaps get them suspended, maybe even permanently. That would send a very strong message. And it could be done in any case I'm talking about. You can still uphold the conviction, saying it's harmless, but send the prosecutor to the ethical board. In our study of the Florida death penalty system, in 35 years, we found one referral of a prosecutor to the ethics board, despite all of the cases involving prosecutorial misconduct. So apparently that's not happening very often. So maybe the only thing that can be done is to try to change the culture. How would that be done? Well, train prosecutors about tunnel vision, about confirmation bias. That would be one thing to do. And secondly, to emphasize what is already in the ethical rules, the prosecutor's ethical rules. Their job is not to win cases. Their job is to do justice. Unlike any other lawyer in the system, in the civil system or defense attorneys, their job is to do the best they can for their client, to zealously represent their client within the bounds of the law. The ethical duty of the prosecutor is to do justice. And if that means helping out the defense, they're supposed to help out the defense, because that's their duty. If prosecutors were trained, and this was drilled into them, that might put a dent in the adversarialism that results in the kinds of misconduct that I've been talking about. So that's one of the structural problems. The other structural problem is actually reverse of what I've been talking about. Not enough adversarialism on the part of defense attorneys. Now, maybe that's because defense attorneys are lazy. Maybe it's because they don't have enough support. Whatever the reason, there are a number of cases where there's clearly been inadequate defense work, inadequate representation by a defense counsel. And without a good defense attorney, innocent people are going to be convicted. Or people are going to be sentenced to death sentences when they shouldn't be sentenced to death. Now, many people who are represented in capital cases by defense attorneys are represented by public defenders. These are defense attorneys who get a salary. And in general, they're pretty good. Why? Because they represent criminal defendants over and over again. The problem with getting a public defender as a defense attorney is they're overwhelmed. They have in many states, they have way too many cases. In fact, one public defender office in Florida went on strike because it had too many cases. And to make the point that it had too many cases, it just said, we're refusing to represent anyone until you lighten our caseload, fire some more attorneys, give us more money. We just cannot do an effective job. So that's the problem with public defenders. Then there are private attorneys. Private attorneys don't tend to be as experienced. Now, obviously, there's some private attorneys who are very experienced. They do only criminal work. But there are a lot of private attorneys who do not do criminal work as a routine matter. Why do private attorneys who do not do criminal work as a routine matter get involved in capital cases and other kinds of criminal cases? Because public defenders often get conflicted out. What do I mean by that? They may be representing the co-defendant of a defendant, and they can't represent both the co-defendant and the defendant. So they have to send one of those two people to a private attorney. There are other reasons why a public defender's office might not be able to represent an individual, in which case the individual is sent to a private attorney. And in Florida, until 2007, these private attorneys were allowed to get, in payment, a maximum of $3,500. That is simply outrageous, given how much work goes into a capital case. On average, a capital case, if done correctly, takes about 2,000 hours. You do the math in terms of what that is per hour. Now, in 2007, the Florida legislature said, okay, $3,500 might not be enough. We're going to be generous and instead set the maximum at $15,000 for a capital case. That's still only $7.50 an hour. That's a little bit lower than your typical civil attorney makes per hour. That's how much private attorneys get paid. You can perhaps see why perhaps representation of individuals in capital cases is not as good as it could be because of a lack of support. And in fact, the Florida Supreme Court has found ineffective assistance counsel in roughly 15% of capital cases, at least according to this study, 50% of the capital cases in which it heard an appeal over a 6-year period. That's a pretty high rate of reversal. It shows that even the Florida Supreme Court, which is not willing to overturn a lot of cases, nonetheless has been willing to do so in 15% of the capital cases it saw over a 6-year period. And this is what one of the justices said about the representation of defense counsel. The capital cases coming before the court have involved the worst lawyering I've seen. I'm not sure we have enough quality lawyers out there to be able to pick up the slack. That's pretty damning language in terms of the kind of representation that's involved here. So those are some of the reasons, not all the reasons, but some of the reasons why innocent people might be wrongfully convicted. What I want to talk about after the break is the following subject. What about those people who are accurately convicted of capital murder? In other words, they
वर्ड का मतलब ही नहीं पता। इनफैलिबल मतलब क्या? Capable of making mistakes. False. The Constitution is required to hand over all the files to the defense to trial. Not really. They are actually, they are. Private attorneys in Florida also can yeah, true. तो मैं तीनों करेक्ट चलो मैं खुद को ही सेकंड गेस करके वो कर दिया हाँ नहीं है ऐसा कुछ वो नहीं है नहीं करे तो चलेगा बट करनी चाहिए ये लोड नहीं हो रहा है ओह असाइनमेंट आ गया कूल बस ये असाइनमेंट करके मैं निकलता बाकी 3 वीक बचेंगे वो कल कर लूंगा मैं सॉर्ट चलो अच्छा वो ये अभी असाइनमेंट नहीं है ये तो वो है नहीं ये तो बीटी वाला है ये नहीं Research shows that some judges impose harsher sentence close to election time. अबे इसका वीडियो तो देखा ही नहीं अपन ने ब्रो इसका वीडियो तो दिखाओ वीडियो लोड ही नहीं हुआ क्या इसका वीडियो लोड ही नहीं हुआ
about numerous reasons why innocent people might be wrongfully convicted. Now we're going to talk about a different situation. A person who's not innocent, a person who has been convicted, and we'll assume that the person has been rightfully convicted. That is, there were no problems with trial, the prosecution was able to show beyond reasonable doubt the person committed murder. But that doesn't end the process, because remember, as I said at the very beginning of this lecture, it also has to be found, before a person can be sentenced to death, that the person is one of the worst of the worst, one of the worst of the worst murderers. That can be a very subtle and very difficult decision. But there can be mistakes made in this process as well. And these are some of the reasons why mistakes can be made. You see here listed ineffective assistance of counsel, the effect of digital elections, jury confusion, and racial bias. I want to talk about all 4 of these. Now, we've already talked about ineffective assistance of counsel. It can cause problems at the sentencing stage, just like it can cause problems at trial. How so? Defense attorneys don't do sufficient preparation. They don't get all their ducks in a row in terms of presenting mitigating evidence. And here you have another damning statement by the Florida Supreme Court. The undisputed facts of this case present a blatant example of counsel's failure to investigate and prepare a penalty phase defense. Once again, and I want to emphasize those words, once again, we have a lawyer appointed who had absolutely no experience in capital cases. Oof. So you can have ineffective assistance counsel claims with respect to trial, and also ineffective assistance counsel claims with respect to sentencing. And there can be reversals in both situations. What can be done about this? Well, it's fairly obvious. Train defense attorneys better, pay them more, provide them more resources, and, as with prosecutors, discipline those who do a particularly bad job at representing their clients. So that's one problem with the sentencing stage. Another problem, perhaps not as obvious, is the populism that I talked about during the first lecture. Remember, during the first lecture, I talked about the fact that compared to European countries, for instance, America is a particularly populist democracy. It tends to be much more responsive to what the polity wants in terms of legislation having to do with criminal justice issues. Well, populism not only plays out in terms of legislation, it also plays out in terms of who we have in the judiciary. Because in virtually every state in the country, judges are elected, not appointed. Now, at the federal level, judges are appointed, but at the state level, judges are elected. Judicial elections used to be pretty sleepy affairs. But in the last 20 years or so, judicial elections have become much more heavily contested. Now, 9 out of 10 judicial elections are contested. Much more money is being poured into judicial elections. And that could have an effect, I'm not saying it does, but it could have an effect on what happens during capital cases, especially the sentencing phase of capital cases. And there's some research to back that up. For instance, this research finds that death sentences are more likely to be imposed the closer it gets to the end of a judge's term. So if the judge's term is 4 years or 6 years long, the judge tends to impose death sentences closer to the end of that 4-year or 6-year term. That suggests that, in fact, elections do have an impact on who gets sentenced to death and who doesn't, which also suggests that maybe some of these death sentences are not accurate, quote unquote. There's also research that suggests that in Florida, judges are much more willing to override a jury recommendation of a life without parole sentence and instead impose a death sentence the closer it gets to election time. And in fact, overall, in Florida, judges were 3 times as likely to override a jury recommendation of life in favor of a sentence of death than they were to do the reverse. They're 3 more times likely to impose a sentence of death overriding the jury than overriding the jury in terms of a jury recommendation of a death sentence. So again, that might suggest that the fact that judges are elected is having an impact on death sentences. The Florida Supreme Court is also elected, and there's an interesting study that looked at Florida Supreme Court opinions before the year 2000 and after the year 2000. What happened in the year 2000? The governor and the legislature began a campaign against the Florida Supreme Court and its quote-unquote pro-death penalty, anti-death penalty decisions. It's quote-unquote anti-death penalty decisions. And shortly after that campaign, the study found the Florida Supreme Court began to change its approach to death penalty, became, if not more pro-death penalty, at least less anti-death penalty in its decisions. So conceivably, once again, the fact that judges are elected is affecting the death sentence process. Perhaps more problematic than the possibility that the election process is affecting the death sentence process is that juries are confused about what they should be doing. Now, what should happen in the typical case is the juries weigh the mitigating factors and the aggravating factors. As I said earlier, if the jury decides the mitigating factors outweigh the aggravating factors, it should impose a sentence of life without parole. If, on the other hand, the aggravating factors outweigh the mitigating factors, the jury should come back with a death sentence. Now, as I've implied just a second ago, in Florida, the judge used to be able to override whatever the jury recommendation was. That law has now changed. Now the jury decision is final. Judges no longer have the authority to override jury decisions. So whatever the jury says goes. So it's particularly important that the juries understand what they're supposed to be doing. Unfortunately, that doesn't seem to be the case. Studies have shown that large percentages of jurors do not understand their instructions. The instructions are given at the death sentence phase of these cases. So, for instance, in this first study you see here, this is a study of people who actually served on capital sentencing jurors. In other words, they sat through a capital trial. They've been given instructions. And then they were quizzed about what their instructions meant. And what these studies found, among other things, is that 49% of Florida capital jurors did not understand they consider any mitigating evidence, not just evidence of mental disability, but anything that in any way mitigated the defendant's culpability. They didn't understand that point. 48% of Florida jurors erroneously believed they must find mitigators beyond a reasonable doubt. That is not true either. And about 36% of Florida juries thought that if they found the person to be dangerous, they had to sentence the person to death. They were required to sentence the person to death. That's also not true. So these are substantial percentages of jurors believing something that's not true in terms of how they're supposed to analyze a death case. Now, one thing that can be done is better instructions can be given to the jury. We can find out why jurors are confused, and come up with better language. But research shows that even those better instructions do not completely alleviate all the jury confusion. So that conceivably creates some concern about the confidence we can attribute to jury verdicts. And then, just like with everything else in the criminal justice system, we have to talk about race. Okay, one of the reasons the Supreme Court decided Furman versus Georgia, the way it did in 1972, was concerns about the fact that a disproportionate number of African Americans were on death row. That's still true, though to a much lesser extent than used to be the case. There's much less disproportionality in terms of black versus white defendants on death row. However, there is still a huge problem with race in terms of race of the victim. Because what study after study has shown is that when an individual kills a white person, they're much more likely to get a death sentence than if they kill a black person. Here's the best study in that regard. 1/4 to 1/3 of death sentence defendants with white victims would have avoided the death penalty if the victims had been black. Okay, that's a national study. Here's a study in Florida. A defendant who kills a white is 3.4 times more likely to receive a death sentence than a defendant who kills an African American. That's a pretty stunning statistic. So, what have the court said about this? Well, the Supreme Court in McCluskey versus Kemp, as you can see cited down here, said it didn't care about this particular problem. Despite the statistical information I just showed you, which the Supreme Court was given, it ended up affirming the death sentence in which this evidence was presented. It gave a number of reasons for its conclusion, but this is the main one. Quote, apparent disparities in sentencing are an inevitable part of our criminal justice system. Well, that is true. That is an accurate statement. But when the disparity is a result of race, perhaps the court should have been a little bit more concerned than this particular sentence evidences. Because if in fact it's the case that if you kill a white person, you're much more likely to get a death sentence than if you kill a black person, that not only calls into question the racial integrity of our criminal justice system, it calls into question the accuracy of our death sentences. So I think this is a very real concern. So what I've talked about are a huge number of reasons why we may be imposing capital murder convictions on people who are innocent, and why we may be imposing death sentences on people who should not or do not deserve a death sentence. Talked about coerced interrogations, suggestive identification procedures, incompetent labs, prosecutorial adversarialism, defense attorney inadequacy, and I've talked about the possible impact of jury confusion, judicial elections, and race issues. Now, I've talked about that primarily in the context of capital cases, but I think you can understand why this is not just a problem. These are not just problems with capital cases. These problems infect the entire criminal justice system. There are flaws that can affect non-capital as well as capital cases. So that's important to keep in mind. We have problems throughout the system. There are disparities, as the court suggested, throughout the system, and those are disparities that we should worry about. There are ways of taking care of some of these problems, but they're very real problems that need to be addressed if we're really concerned about accuracy in the criminal justice system. This article here goes into much more detail about all of this. So what we've done now is talked about the criminal justice system. What we'll do in the next two and final two lectures is talk about what happens before we get to the criminal justice system. That is, before we get to trial. In particular, we're talking about the police. How do the police go about their business? How do they figure out who to arrest? How do they detect crime? Our last two lectures will be about those topics. But that's not what we're talking about now. We're talking about the criminal justice system and its flaws. So I'm curious if there are any other questions about that issue before we end today's lecture. Yes.
Are there some states that currently enforce the death penalty that are already starting to implement some of the recommendations you talked about that are, I guess, ahead of Florida, or is Florida mostly the norm?
I would say Florida is the norm in the South, to put it bluntly. it's not the norm in other parts of the country. For instance, you may have heard California's governor just put a moratorium on the California death penalty. I think one of the reasons he did that was because of what I've been talking about. There are concerns about the accuracy of the death penalty process. It's also extremely expensive. I think that may be another reason the governor imposed a moratorium on the death penalty. And in terms of the gist of your question, a number of states have been very worried about the problems I've been talking about. The state of New Jersey, for instance, has been very aggressive in reforming eyewitness identification procedures. A number of states have started videotaping interrogations. There have been some states that have started pouring more money into the defense attorney system and the public defender system. So there are states that are aware of these problems and are trying to take steps to address them, but not all states, and even the states that are doing some of these things maybe are not going as far as they could and should. Any other questions? Okay, well, thank you very much.
अभी है इधर पढ़ना हो तो पढ़ने का ना debating the death penalty. Okay. Describe the pros and cons of capital punishment, providing 2 reasons that might be given in support of the death penalty and 2 reasons that might be given to oppose it. Okay. अब इसको रखो साइड में, मैं आता आगे. Evident, निजम. I don't want to evolve, dude. Come on. बोलो मिस्टर मर्सी, कसं काय? ये पोपलू वो लेके एक चला गया है स्टैंड। वीक 4 है क्या किसी का? वीक 4 है। इसका तो कर दिया मैंने, इसका हो गया बे। वीक 4 और किसी का है क्या? टू टू 6 ये क्या है? अच्छा ये फिर 5 या 6 होगा. ये ऑन जाए. जाए. हो गया सॉर्ट. और कौन सा है? Police use of surveillance technology sentencing engagement. ये नहीं हुआ है क्या? और होता है द डेथ पेनल्टी. हाँ ये दे. यही चल रहा है अभी मेरा भी, डिबेटिंग द डेथ पेनल्टी. और किसी का नहीं है, एक और करना है उसको, डिबेटिंग द डेथ पेनल्टी. Police power, use of surveillance technology, debating the death penalty. चाहिए. चलो ये भी हो गया, डिबेटिंग द डेथ पेनल्टी कंप्लीट. और कोई बाकी है? हो गया डन. चलो ये अपनी वीक 4 भी खत्म हुई. अब 5, 6, 7 बाकी. नेक्स्ट. चलो आज की स्ट्रीम इधर खत्म करते हैं. ये क्या है?
Well, newly released video of the deadly shooting of a black man by a white police officer in Tennessee is spurring calls for the officer to be charged with murder. Prosecutors released the surveillance footage yesterday. It appears to show Nashville police officer Andrew Delkey chasing Daniel Hambrick last month before opening fire. Hambrick was hit 3 times. Mark Strassman is in Nashville with reaction to the new video. Mark, good morning.
Good morning. This is the street where the fatal shooting happened that now has Nashville's mayor calling for a complete review of the police department. These flowers mark the spot where Daniel Hambrick fell, fatally wounded. The police union says there's a lot more to this story than what the surveillance tape shows, but Hambrick's family is demanding more answers.
ये तो स्कैम हो गया बेचारे के साथ.
I just want justice for my son and my family.
Victoria Hambrick, supported by her family and attorney, believes video showing the shooting of her son Daniel Hambrick on July 26th is proof that police deadly force was not justified.
The police officer chases him with his gun drawn, and at some point he slows down and executes him.
Police say Officer Delkey was searching for a stolen car when he ran into Hambrick. The video appears to show Hambrick running from the officer before he was shot in the back and head. Police later tweeted a picture of a gun they say Hambrick was carrying and refused to drop. The Nashville Fraternal Order of Police argues Hambrick could have shot the officer at any moment.
It is our firm belief that Officer Delkey acted reasonably under the totality of the circumstances.
No, he should have
Nashville
shot him.
Mayor David Briley called
He
for
should have
calm
shot him
while the investigation
in the
continued.
thigh.
Getting it to the bottom
Or
of
in
this
the
is
arm.
very important. It's
Not in the
equally
head.
important that while we pass time waiting
shot
for the
दिया है
investigation to be complete,
एक आधो body shot
that we
देता
be
तो
patient.
भी वो
But the
रुक जाता
Hambrick
था.
family believes this is an open and shut case.
You can see my cousin running for his life. There's no way that he is a threat. No way. And we do want justice served for him. Did not deserve it at all.
Officer Delkey has been placed on administrative leave. He wasn't wearing a body camera and his cruiser did not have a dash.
चलो भाई बहुत पढ़ लिया आज के लिए बंद करते अब थक गया भाई मजा आ गई कितने घंटे हुए ओ भाई 3 घंटे हो गए बहुत पढ़ लिया भाई बहुत पढ़ लिए 3 घंटा पढ़ लिया ऑन स्ट्रेच 12th के बाद इतना ऑन स्ट्रेच कभी नहीं पढ़ा है मैंने चलो थैंक यू फॉर ज्वाइनिंग इन ऐसी टाइम पास वाली स्ट्रीम में भी आते हो मजा आती है थैंक यू